following podcast contains opinion and commentary protected under the First Amendment and fair use, as well as the public records and freedom of information laws. The content may include adult themes, concepts, or language not suitable for all audiences. Viewer discretion is advised.
Inside, take a seat, let the stories feed your soul. Hear the echoes, find the patterns, every truth, each hidden role. From the bench to the whispers, where the gavel takes its toll. There's a rhythm in the verdict, echoes from the cubby hole. Echoes, echoes from the cubby hole, where justice swings and stories unfold.
Welcome, everyone, back to your favorite cubbyhole on the internet. Oh, it's Sunday. Monday is upon us, isn't it, folks? Hope you're doing well. Hope your weekend was decent. Mine was okay. I had to work. As often happens on the weekend because, you know, the economy is never good enough for one job to suffice for many people, unless you're lucky. But I'm not lucky. I just work my ass off, and we're grateful for what we have. Now, you might notice that I'm all by myself for this evening. No, Jeep Daddy isn't here at the moment. He's allegedly, according to the text I received, finishing a hair appointment. I don't know why hair appointments happen on Sunday evenings, but evidently they do, and he had one. So let's see. Well, you know, I do like amusing disclaimers. If you're so inclined, that could apply for certain people. But I digress. So Jeep Daddy may join us eventually later or not. I don't know. We shall see. But we have plenty to cover without his interjecting from time to time. So let's just get to it. I could have done all kinds of little bits already. Let's see. Hi, chat. How are you? Happy Sunday evening. Happy Monday Eve, I think might be the phrase. All our lurkers are hanging out, who are either hanging out in chat and just listening, or just listening and not hanging out in chat. Whatever is your preference. Welcome, welcome, welcome. Some interesting things have indeed happened as at the end of the last week. And it's intrigued me. Because the usual suspect, that being one Dingus the douche canoe,
the fucking douche canoe,
has entered the fray even more. He has entered indeed. He can't help himself because it seems to me, and these are my opinions, it seems to me there is an unhealthy infatuation with this client. We take all kinds of things pro bono. We get involved in all kinds of things, including injunctions and trying to have limited purpose appearances for bankruptcy cases, and sort of helping on the side with adversary parts of bankruptcy cases. It's just odd to me. It's odd. Hey, Rob. Hope you're doing well. So, yes, it's going to be a big week for Rob. His first, hopefully his first and only hearing will be at the end of the week on Friday, if I'm not mistaken. One Dingus the douche canoe, and this is stirred about on Twitter, so I'm not speaking out of turn. Dingus the douche canoe has showed up on another podcaster. Well, do I dare call that guy a podcaster? He seems to be a little bit of a shit stir to me. David had appeared on one Just J Hip's show, and I had to catch up because I had no idea this happens. I don't really pay attention to Jay. He's not my cup of tea. He doesn't appear to be many people's cup of tea either, but yet he has a much faster growing channel than I do. So be sure to hit those like and subscribe buttons somewhere right about there. Hit that one, hit the bell. I think, where's the bell? The bell's over that way usually. Or maybe it's over that way. I've got double inversion. Just crazy. If I look at one screen, I'm pointing the wrong way. And if I look at the other, I'm pointing the right way. Down below somewhere there. Hit those buttons. We deserve to be growing larger and quicker than just J-Hip. And that's just my my snarky opinion about it. So yes, David has indeed entered the fray even further. That's why I titled the thumbnail as I did. The Clown Show, as I predicted on our last session. The Clown Show is beginning because David is getting involved even more. He can't help himself. I do not know why. Oh, and I promise, Marcus, it's not in my nature to sacrifice likability for growth. I like to think I'm naturally likable. I may not be. I probably am not to David. That's his opinion. He can have it. I don't give a care. But I like to think I'm slightly adorable. Just slightly. As opposed to, medium smart, I'm slightly likable. So he is. He's involved. So let's get to the boring one first, and then we'll do the interesting one first. And I happen to hear someone who is new to me. He is an attorney in Michigan. His name is David as well, strangely enough. And he has Making Law Simple is the name of his YouTube channel. So I've started listening to some of his stuff because he does take a legal analysis approach to what David has been filing, and he's been analyzing the Laura Owens craziness. So, you can't have too many seasoned lawyers that are not David Gingras involved in this talking about it. Because, of course, if David had his way, I think, he would be the only one talking about it and would be trying to sway public opinion based upon what I believe are his rather consistent false misrepresentations. But again, those are my opinions. I don't practice in law. I don't practice in medicine or mental health or any of the other subjects that we tend to cover on this. I'm just another voice who can read some things, who has enough of a brain and enough functioning neurons to see right from wrong and to see at times, again, because I don't practice in law, where some of the things being asserted by one side or the other are not accurate. That tends to happen in adversarial proceedings, as is often the case in various forms of litigation. But yes, I'm just rambling my mouth, as I'm wont to do. And since Cheap Daddy isn't here, somebody has to do it. All right, so let's start with this first little thing. And this was fascinating. This has not been stamped, so this has been circulated a little bit. I will imagine it will hit the docket in due course after the holiday on Monday. For those of you who get the holiday, good for you. I don't. We only get major holidays, and it's just boo. It's boo worthy. Yeah, I don't like not getting all the holidays, but it is what it is. Well, thank you, Jody Who, for that. I like to think I'm slightly likable. And I'm loath to even talk about it because when I saw all the Twitter back and forth, Lauren Knighty made some very salient points talking about the inappropriate and just despicable conduct David Gingras has engaged in throughout his involvement in the Laura Owens saga. I thought Lauren's comments were very well considered and certainly very well thought out. And of course, Lauren has her own axe to grind against David, as I suppose I do too. Because, David, saw fit to include mentioning me and my channel in one of his filings with Owens v. Maricini. That's when David was trying to intervene, but not make an appearance to help Laura Owens, which is bizarre. And it sort of seems to me that he's trying a similar tactic, but not phrased in the same way, with stuff going on in Arizona. And first, that starts with the bankruptcy court. So he has filed a motion for leave to enter a limited scope appearance. And as I understand it, again, I don't practice in law, so these are just my opinions for what they're worth. This is an unusual request, which is why it's a motion for leave number one. Motion for leave is a typical phrase used when things are not generally following usual procedure. So it's like a special request of sorts to water it down somewhat. Oh, Emily Laura Wilson says, I think I'm totally likable. Me. And hilarious as Blowen's failures in court. Well, we hope she continues to make the failures she's entitled to make, especially if she continues involving David. But that's her folly, and if he's brave enough to keep swinging at those balls and constantly hitting strikes. I suppose that's his entitlement and his folly too, but I wonder how he's paying his bills if he's doing all this pro bono, and allegedly that's how he's handling this. So let's see. I don't know about MLS being an idiot. He seems to struggle with pronouncing some things, like he said defamation a few times, but didn't say defamation. He said deformation, which is an entirely different word. And he said a few other things. He struggled with names. I was kind of scratching my head a little bit. I don't have a specific opinion on him based upon what I've seen so far. I've seen a few hours worth of his content talking about Laura Owens. He says he's a practicing, I think he said, a criminal defense attorney in one of his videos. So it's like, well, he has to know something, right? I hope, maybe. But again, it's just first impressions based on what I'm seeing. And again, because I don't practice in law and that guy does, the conclusions I made on my own prior to seeing his videos were pretty much in alignment when it came to the injunction with Rob that he was analyzing and the responses as they stand and the disposition of the case so far. So that was interesting. And, you know, I'm not so full of myself as to say, oh, if it's not totally favorable to one side or the other, that then he's an idiot. I thought his comments were reasonable. And as a practicing attorney in Michigan, he is somewhat aware. I mean, he did go to law school, so there's that. But of course, as he very accurately said, he does not practice in Arizona. He was not thoroughly reviewing Arizona law. With his commentary, he did some quick and dirty little things, I guess, sort of on the fly. But I sort of reached the same conclusions. I didn't talk about them a whole bunch on the last live stream. Just because I tend to ramble if I start thinking about technicalities too much, and that just gets boring for everybody, and you do not want to be bored. There is enough stuff here for you not to be bored. And Bruce is not a fan of all the coughing. I don't know who's coughing, but that's okay. It's probably me. I try to hit the mute button, but sometimes I miss it. Coughing and sipping water is what I do behind the scenes. It's something I'm very good at backstage. So this is the document by David for the limited scope appearance request. And he also wrote, and I didn't find this interesting, so I'm not going to cover it, but it is there. He also wrote a proposed order for the court to sign. We shall see what the bankruptcy court decides to do, because I'm not so sure. The DOJ, that being Jennifer Jaimo, if I'm pronouncing that correctly, she didn't see all too keen to have him there at all, let alone saying anything, because he did not make an appearance. And this whole little, well, I want to be part way in only to help Laura, but I don't want to be all the way in. I suspect, and again, I'm not speaking for her, but this is just my perception based upon what she was saying in the last hearing we heard. I suspect the DOJ trustee is not going to be all too interested in having David sort of flitting in and out as he wants. I'm not so sure they're going to like that. So we'll see what happens there, but let's just read through this for consistency's sake. You know me, I'm a little bit of a completionist, so here we go. See, did I actually? Okay, good. Pursuant to federal bankruptcy, etc., undersigned counsel David S. Gingras respectfully moves for an order allowing him to enter a limited scope appearance in this matter on behalf of debtor Laura Owens. Herein, Miss Owens. As this court is aware, local rule, etc., takes an all or nothing approach to an appearance of counsel, i.e., when a lawyer enters an appearance in a bankruptcy matter, the lawyer is ordinarily responsible for all aspects of the case until counsel withdraws or the case is closed. That doesn't seem unreasonable in certain proceedings to me, because what you don't want is a lawyer sort of bouncing in and then, I'm out, and then the poor client's left high and dry. So I could see that being problematic. Number one, general appearance. An attorney who files a debtor's bankruptcy petition or who files a notice of appearance on a debtor's behalf must represent the debtor in all matters other than adversary proceedings until the case is closed or the court enters an order approving withdrawal or substitution of counsel. If I can find the right place in my multifocal lenses, which when it gets this big, folks, it's difficult. I'm not going to lie. The bigger it gets for me, the harder it is, because then I have to crane my neck to get to that good spot in my... getting old sucks. Okay, I digress. Undersigned counsel currently represents Ms. Owens in the associated adversary proceeding. Arizona state courts historically applied the same standard. When a lawyer appeared, the lawyer was responsible for the whole case until the matter concluded or the court permitted withdrawal. This was the default rule for many years. Recently, although he doesn't say when, I just love vague terms. It is vague. Recently can mean anything. I mean, what's his definition of recently? Courts have begun to realize this all-or-nothing approach was too harsh because it could often deprive low-income litigants of the ability to obtain counsel who may be willing to appear, but only for limited purposes. Okay, this is like halfway to sovereign citizenville of having like standby counsel. That's ridiculous. And things of this nature, which when it comes to money and numbers and those kinds of things, again, I don't practice in this kind of craziness, and I certainly don't practice in bankruptcy anything. We know a little bit about money. I like spending money. I don't like borrowing money because I don't like having to pay it back with increase or interest. So we try and avoid that. But generally, we do like spending money we do have. For that reason, in 2003, the Arizona Supreme Court modified the rules of professional conduct to expressly permit lawyers to engage in limited scope of representations. See, etc., stating a lawyer may limit the scope of representation if the limitation is reasonable under the circumstances and the client gives informed consent. Oh dear, we have another conformed consent. Oh, okay, you guys are talking about Hales in chat. I did hear MLS talk about. I don't know if it was I think it was lips he was talking about, and that did raise an antenna. I'm not caught up on all the Hales and all the peripheral people, so again, I've only seen so much, so I'm not going to over-represent what I've seen and what I believe so far. But as it concerned Laura Owens, and again, stuff we'll cover in a minute. I was not surprised at what he was saying and what his legal position was as a practicing attorney in Michigan. But again, different things. Don't distract me, Chad. I'll come back to that. Based on the change, Arizona rules of civil procedure, especially authorize limited scope representations in state matters without leave of court. I think that's different with bankruptcy. Bankruptcy is a little tighter run. Although Arizona's state courts have embraced the benefits of limited scope representations, the federal courts have not yet adopted local rules which address this beneficial practice. Boy, this is like persuasive language. We're trying to convince everybody. Despite this, Arizona's federal courts routinely agree lawyers may properly appear on a limited scope, even without seeking prior leave to do so. Federal rules of civil procedure do not expressly authorize or prohibit attorneys, blah, blah, blah. I'm tempted to skip this. So this is just a loose citation. All right, fine. Moving along. Here, just as FedR permits district courts to adopt local rules, provided they are not inconsistent with federal law, Bankruptcy Rule 9029A1 grants that same authority to this court. I wonder if the court agrees. As such, this court may permit a lawyer to appear on a limited scope basis if good cause exists. That doesn't mean there won't be objections that may be heard. Here, good cause exists to allow undersigned counsel to enter a limited scope appearance in this matter. First, the undersigned is representing Miss Owens entirely pro bono. Entirely. He said entirely, folks. Do you see that? So if that turns out not to be the case, because in the injunction matter, he is asking for fees and costs, which we'll get to when we talk about the injunction. He says he's entirely pro bono in this filing. So if that's not true, and he's therefore asking for fees and costs in another filing, I see that as problematic. Ms. Owens is currently seeking a Chapter 7 discharge from this court, and she claims substantially no non-exempt assets and no meaningful income aside from support she is receiving from her parents, which is her entire life. How is that not meaningful income? The DOJ Jennifer, maybe that's her name. I'm still trying to find a good nickname for her. I don't think we found it yet. DOJ Jennifer. She very astutely pointed out to Laura that everything she is receiving from her parents for her lifestyle is income. It may not be cash money in her personal bank account, but she is being taken care of. And it's also interesting that mom and dad in their Chapter 13 did not claim they were supporting anybody. So who is supporting who and who is not supporting who, I would imagine, is a conversation the bankruptcy court is entertaining. And they're probably waiting to receive more information from other creditors and debtors and all of that stuff. Miss Owens. Oh, let's see. Yeah, Miss Owens is unable to pay for representation of counsel in this matter. Did I say that right? I'll say that one more time, just for thoroughness. Miss Owens is unable to pay for representation of counsel in this matter. That sounds odd. As a sole practitioner who is familiar with the history of the events which preceded this action, undersigned counsel is willing to provide some, a qualifier, some legal services to Miss Owens on a pro bono basis, but without any pre-established limits. I want to be able to do what I want. I don't want to have any limits. I don't want you to tell me that I can't leave when I want to. Yeah, I'm not so sure they're going to go with this. I'm not so sure. For that reason, undersigned counsel proposes to appear for Miss Owens in this matter with her informed consent under the following conditions. So yeah, this is trying to persuade the court to let them do something that is, what's the word, irregular? Irregular. If leave is granted, counsel will appear for Miss Owens in this matter and will handle all aspects of the case. Now, wait a minute. You're either handling all aspects or you're not. Because earlier we try and convince us that that's not necessary. This is bizarre. He says at the beginning, the lawyer is ordinarily responsible for all aspects of the case until it's withdraws. So what's the point? You get her so far and you leave her high and dry? I mean, I don't get it. What benefit is there for her? And again, as I've stated before, my opinion of his ability to practice so far is pretty low. My opinion of his expertise and success is not very high. And again, that's opinion. I'm allowed to have my opinions. Oh, boy. Let's see. The period should be sufficient. Oh, so, okay, back up. If leave is granted, counsel will appear for Miss Owens in this matter and will handle all aspects of the case for a period of not more than 60 days from the date the court grants leave. Well, why 60 days? What's so important 60 days? This period should be sufficient to complete any discovery the trustee currently seeks. So this is to manage discovery issues. Very interesting. Let's see. As indicated in the trustee's recently filed application for 2004 exam. If this matter is not resolved before the expiration of the 60-day period, counsel may agree to continue representing Ms. Owens for additional limited periods as necessary. David, either you're in, you're out, I think is what the court's going to say. It's a strange request. If the amount of work required by additional discovery requests from the trustee or any creditors becomes excessive, undersigned counsel may terminate his representation of Ms. Owens by filing a notice of termination of limited scope representation. Upon such filing, counsel will be deemed to no longer represent. He's trying to make his own rules, I think, is what's happening here. This is weird. This is really weird. For the court's information, undersigned counsel previously met and conferred with trustees counsel Jennifer A. Giaimo regarding this issue. Miss Giaimo indicated she would not consent to undersigned counsel appearing on a limited scope basis without leave of court. For that reason, leave is requested for the reasons stated above. Yes, so as I said earlier, she's not keen, that being DOJ Jennifer, to letting David just sort of waltz in and out willy-nilly within 60 days or however he feels he wants to do it. And we'll see what happens. Okay, let's see. All right, chat. I'm going to get caught up a little bit. Let's see. Long Eli, Giaimo. I think I said that, didn't I? Giaimo? Maybe I'm not. I don't know. I won't lie. Italian names kind of befuddle me a little bit. I get the vowels backwards. I studied German, not Italian, and they're different. Let's see. What else? Let's see. David loves to be all the way in, but only outside the court. That may not be the only thing. The fleas cough, then Jay coughs. I'm glad I don't pay that close attention. I listen to Tug and Megan, and that's about it. I don't have the bandwidth for lots of Hale stuff. It's too big. It's too big for me. And to try and keep any sort of rational pulse on what's going on with Laura Owens, I cannot follow Hales at the same time. It's just too much for me. Let's see. MLS stock Jeremy Hales doesn't seem like a nice guy. Really? Well, I don't know about that. I would think if that were true, he would have been charged with something if he was legitimately stalking. Yeah, people like to, this is the interwebs, folks. People like to go digging about other people. And then even people like David Gingras, who went around and doxed just about everybody who's ever talked about him. And then he feigns sort of ignorance that, well, people dox me too, as if that's justification. But David, you're a publicly practicing attorney, is my opinion. If you're out there and you're involved in a high profile case, which I believe this qualifies, people are going to know about you and they're going to do research about you, as they're wont to do, just as they are about your client. Let's see, are you not a fan of all the coughing? I'm just reading through chat a little bit before we change subjects. Hi, Susan Dippity. Bit late, mostly behind doing other things. Well, thanks for joining us. Sometimes I miss my own lives. No, I don't. I'm here. They either happen or they don't. Sometimes I've scheduled one and changed my mind just because of various things. I've got enough to listen to as is. Yeah, well, there's plenty to listen to, that's for sure. Let's see, just did a Google, but nothing on the first page results. IB says, yeah, I don't know. MLS got himself sued by Hales for flat out lying. Really? He knows he lied, so he's lawyered up. He also went to Hale's home in Ohio and took pictures, which he posted online. Really? Well, I don't know. This is news to me, if that's true. I can't verify that because I wasn't there, nor did I see any of that, nor have I seen any of the story. So I can't speak to that. Not following the Hales, but it's not good. Let's see. On Tizzy call. On Tizzy call? He never expected anyone to see this. I don't know what that means. Let's see. Jody Tizzy. Okay, that's someone I haven't heard of, folks. MLS drove Legally Live off YouTube. Legally Live. Is that Lips? See, yeah, you guys know more. You guys must have more time than I do. That's all right. It's okay. There's lots of stuff. Marcus says, to get caught up on what the hell is you got to quit your job and steal toys. Well, that's not going to happen. I'm not going to quit my job or jobs, and I'm not going to go stealing to make up the difference. It's just not going to happen. See, Bruce says, I learned about loofah colors from What the Hell's case. Yeah, I learned a little bit about, what was it, loofahs on go-karts? Is that what it was? Loofahs on go-karts? See, not sure if same as Hales, since I know nothing about Hales. Let's see, embarrassing. Let's see, teeth, cross purposes, actually, O's minus babies. Boy, chat's busy tonight. Oh my goodness. Suzanne says MLS helped hella excited utterance behind the scenes with all the legal stuff when she covered LOVECE a year ago. Dali Taco's Hella's co-host and is local to AZ. Dali was in the chat. MLS's 2 LO videos. Okay. I'll take your word for it. I did make a comment on MLS's, I think it was the one yesterday, where I made a posit that because of how she's presented herself publicly, and she has done so, Laura has appeared on her popular father, Ron Owens, radio show a number of times. Of course, also her sister. Laura and her mother had a commercially sponsored podcast that they claimed was at the top of the charts, the Apple's top whatever list of however many years. Whether that's true or not, I don't think I believe, because I did do some research on that and I found some indiscrepancies in the disclaimer. But they were commercially sponsored. It was out there for the public. I tend to think of especially commercially sponsored podcasts to be more along the lines of radio. I don't know if the courts see it that way or not. I don't have any basis other than my hunch is that because they have a similar format, they've got in-program commercials. YouTube does that because it's YouTube's platform and I can't do anything about it, even if I never monetize. I think because, as I understand it, broadcast people are considered, I can't talk, at least limited purpose public figures, if not actual public figures, because they are engaging in topics of public interest in the public sphere. Laura Owens and her mother, Elizabeth Ann Naylor Owens, aka Jan Black, they had self-help podcasts with a number of notable names. I couldn't tell you what all those names are off the top of my head because I didn't listen to many of them, and I found it just too frou-frou. It was just weird. And it was scripted, and it was just... Nobody Told Me podcast I felt was very inauthentic. It just seemed something to keep everybody busy and try and make as much money as they could. And it sounded like for a period of time they did, even though Laura partly misrepresented that, or was it her mother that said there was no money in it, or... I don't know. I'm forgetting who said what now. There's just so much going on. It hurts my head. It does. It hurts my head. But anyhow, I think of people who are that far into the broadcast space, be it the platform of podcasts, radio, whatever, because you can connect to the world and the world can connect to you via the internet. I see that as being the same sort of category. You're broadcasting, you're a broadcaster, you've got a podcast with a specific show. It's no different than being on a radio show. I disagree with MLS in that Lore Owens is not a public figure. He says he's the lawyer and he knows, so that there's that, but whatever. And he also said that it didn't really matter because it's not about her being a public figure. These are First Amendment issues and they're issues of harassment. So let's change panes, shall we? Let me bring up the other document. So let's see. Oh, let's see. I've got to take this down. Then I've got to do this because StreamYard is stupid. And let's see. Take that down. All right, let's see. Share that thing. Share this thing. This is just so clumsy. They need to have me redesign their interface for them because this is just clumsy. See, is this the right one? Yes, I think it is. You don't need to see my software updates because that's just silly. That would be very silly. So this is written by David Gingras. This is his motion to quash, which he says, according to his verbiage in his statement on Just J Hip's channel earlier today, as a matter of fact, that he filed this, I believe he said Friday, as well as his appearance. So my first concern with all of this, and until I saw him talk about himself and Laura on Just J Hip's channel, was that number one, David was filing a motion before filing an appearance. But ostensibly, allegedly, supposedly, we will see that there is a notice of appearance that will appear in the docket after the holiday. With David Gingras supposedly, allegedly, pro bono representing Laura Owens in the injunction case with HeyRob. Why did I hit that button? That was silly. I just made it go away. That was dumb. Nobody told me. Hi, Lauren. How you doing? Good to see you. I didn't know Lauren was here. See, I'm only half paying attention to chat. When Jeep Daddy is not here, I can only do half a good as a job. The job is only half done. We kind of trade places, poking at chat while the other reads. And when I have to do everything, it's just more work. It's lots more work. I mean, anybody who does this on their own, kudos to them. All right, this is the response to the motion to quash. I hope you have your popcorn, folks. If you don't have a treat, go and get it now. I'll give you a moment. I could have done this as a ginger bite, but I didn't want AI to summarize it because it was just junk. So we're going to read this one right down to the whole thing. Bruce. Nobody told me to do accounting. Nobody told me how to run an LLC. Nobody told me not to file bankruptcy. Nobody told me to get a job. Nobody told me to move out of the house. All those things could be true. We don't know. Some of them have to be true because most of those things have actually happened. Right? Maybe all of those things have happened. There's that. Oh, yikes. That could be her byline, right? Her one-line sum up at the end of her life, whenever that may happen to be, because none of us ever know when we're going to be removed from mortality. That's just life, folks. No one knows when you get to punch your card. We don't get to control those things, but that could be the thing that her punchline is. Nobody told me, just period, or ... That's not an accusation. It's not a threat. It's just, mortality is what it is, but that could be Laura's claim to fame. Nobody told me. I would bet. I'll bet that's not true, though. I'll bet some people have told her, but she thinks she knows better, and I think she just doesn't listen, among other things. All right, here we have the motion to quash. Laura Owens, plaintiff. HeyRob, defendant. Plaintiff Laura Owens, hereinafter called Miss Owens, respectfully submits the following response to defendant Robert. Well, we'll just say HeyRob. It's just too much. I know how to pronounce his last name, more or less. Andreev, I believe, is how it's pronounced. HeyRob works better for me because that's how we know him. HeyRob is his channel, and that's what he goes by on his channel. So I think I will apply HeyRob just as a matter of course. Oh, boy, chat is really flying. If it gets any faster, I'll have to click a button and slow it down. If it gets too busy, chat, let me know. Like someone yell at me a few times in all caps, and maybe I'll see it eventually. And I can I do that? Maybe I can't do that till I reach 1,000. I don't know. I've never played with the chat tools yet. Miss Owens respectfully submits the motion. Response. Okay, so we have the response to the motion to quash. Okay, very good. Motion to squash and quash. And forgive me, I have marked this up and I've made little comments in the margins and between the lines, as I want to do when poking through these things. Oh, you know what? That's what I was going to say. I've sidetracked myself. See, that's how good I am at doing that. Where did my other thing go? I had some concerns. I had some concerns about this, and I shared with you the first one about that being David officially appearing. But supposedly, as he said on Just J Hip's channel, that he has officially made an appearance. I think the defendant could respond to that. Just as the defense in the DVRO in Owens v. Maricini had a response, which was to follow for disqualification. Because I think, and again, I don't practice in law, but it's my opinion that I think there's a number of conflicts. I think there's a number of problems with David being allowed to represent Owens in the injunction as well. And like I said, the first one was that there was not a notice to appear. I didn't even find the case on the docket, but supposedly it's there. So I was likening this in some of my earlier thinking today of if he did not, in fact, file an appearance. And he says he did, so I'm going to have to take his word for it, because if he's lying about that, then everything he's submitting as pleadings is a problem. At least that's my opinion. Because just like in Maricini, when he was filing all of that crap, which named me and it named Ducky and it named Lauren, the court said, no, we're not doing this, and called it a sideshow. And he was not granted an appearance, I think is more or less how that happened. And of course, Omar filed the motion to disqualify preemptively, which the court essentially rendered moot because it wasn't going to let him in. I think similar things could happen here. I don't know that they will, because I do think there are conflicts of interest here. So those conflicts being, as I see it, that David being involved and representing Laura is potential retaliatory move, in my view. As you know, those of you who've paid any attention to Rob's channel, Rob has been very involved in getting information, court documents of the criminal case. I don't know if he's done much about the bankruptcy case, but I think he may have picked up some things there. He just seems to, it's like going into Costco. Every time he's going into the Costco of the court system, he's picking up packets of documents about Laura Owens' stuff and David Gingras' DUI stuff. So I may be wrong on that. Rob can correct me if he's only done a few things. I'm not so big as that I can't be corrected if I'm incorrect. It's okay. Just as in David being involved in representing Laura in the DVRO case, after they had a conversation with David, who was trying to glean information to, supposedly, according to Rachel Juarez and Omar, and I don't see any reason why either of those people would misrepresent the hour-some-long conversation they had with David Gingras. I see similar problems. David's looking to be involved not only for Laura's benefit, who I'm sure Laura likes the free advice wherever she can get it, but also to save his own skin, because Rob has covered David's DUI case too. Rob has also attended court hearings for both Laura and David, and I think this is a move on David's part as sort of a gag order. I mean, Laura filed it. She made all these accusations of harassment. I don't believe it rises to the level of harassment based upon U.S. or Arizona rules and laws. I don't see that based upon what I've heard and what I've seen and what I've read. Again, I don't practice, so I could be wrong, but this is where the court will untangle things. But I believe this sort of retaliatory moves of Rob being so proactive and participatory in all of these events, both in reporting, commentating, observing, being present in the courthouse, both David and Laura want him gone. I see that as a conflict of interest. I would be curious to know if the courts would see that as a conflict of interest if Rob's legal representation were to raise that issue. And then there's also the other thing that later in this document, this motion to the response to the motion to quash, David Gingras requests reasonable attorney fees and costs. But if he is allegedly pro bono, is he entitled to fees and costs? Because he's working at no charge for Laura Owens, whom he is representing. So I don't see how that works. I don't know if anybody is in chat is more aware of how that could be procedurally accurate to request fees and costs if you're representing somebody pro bono. In which case, if he can, even though Laura's not being charged for anything, and David can hope, if he were to win something, get money out of that, how is that not a money grab? Do you see what I'm saying? I'm trying to understand how you can represent somebody without cost. I mean, there's always some cost, right? There's always filing fees. If he's charging for his time, I mean, see, there's stuff that doesn't make sense to me there. There's some missing logic pieces I don't understand. So I had some concerns about that before I read this document, and that also kind of goes with the the disclaimer. I don't know what else to call it. The disclaimer that until this document is received by the clerk of the court and stamped and is put in the court file for the injunction, this is just David pounding the keyboard. Okay? So I should have led with that, but I didn't. I'm out of sequence. Sorry, everybody. I don't have my trusty sidekick to keep me on the straight and narrow here. Okay, so let's see. Response to the motion to quash. So with all of that preamble, all of those disclaimers, all of my concerns about the procedural postures of things and how things are supposed to be done, because frankly, and let me be honest here, and this is my opinion again, I don't trust David to follow the rules. We've seen him try to do dirty-handed deeds in Owens v. Maricini and some other things. There's a reason that Megan Fox, I think the phrase she called him was a scumbag lawyer. So I think that's a direct quote. I could be wrong. That might be a paraphrase, but that's what I recall her. I mean, I think maybe it was sleazy lawyer. That may have been the phrase. Whichever it was, he pretends. He pretends on camera, in my view, that he's a moral, well-grounded, not a bad person. But I don't see his posturing when the cameras are on. And some have said that he could get Just J Hip's channel in trouble for even appearing on it, for having any major appearance on another channel. So, I don't know. Jay may have opened himself up to losing his channel and getting banned too, just by entertaining David Gingras, who is banned for life from YouTube. That is from David's own lips. So, there you go. The issue, he says, before the court is simple. Does the First Amendment bestow an unlimited right to attack, threaten, harass, and terrify victims with online speech? ? As explained below, the answer is clear. Absolutely not. Threats and harassment are not merely immoral acts. They are crimes in the state of Arizona. They are subject to lawful restraint. And without even getting past this paragraph, when I heard it first read, I knew it was David's writing. I knew it. I didn't need to see the page at the end. David is always the histrionic writer in his filings and pleadings. It's always lots of extremes and lots of histrionics. It's just very dramatic writing. And again, it's my opinion that it's not very good legal writing. And I think this is something, and for those of you who don't care for MLS, that's fine. This is something I think I will agree with him on. That being MLS. Filings and pleadings should be straightforward. They don't need lots of extra crap. They don't need lots of images and articles tucked into them. Just reference the exhibits. Make it as easy for the court and the judge and court staff to agree with you and your position. Don't chuck it full of needless, irrelevant shit. And in good David Gingras fashion, this is full of meaningless, irrelevant shit. And he even, more or less, we'll get to it, says so. I mean, like the first several pages, 5 or 6 pages maybe even, are just useless garbage. They're useless. Why he does it, I don't know. I think his tactic here, and before I continue reading, because I can, I think his tactic here is Oh no, my microphone's gone limp. Okay, you can clip that, folks. I keep trying in a different mic position and it's just not working. I believe David's intent is twofold here, or maybe threefold. Number one, he's representing Laura and he wants to make Laura look like a victim. And number two, I think David, as he has in other filings, where he's named other content creators, myself included, tried to use it as sort of a means of, I'm trying to remember how Lauren phrased it in her filing and her response to the court in San Francisco. Oh, it escapes me. I think she phrased it as using it as a way to sort of slander or libel, I suppose, because it is printed form, make libelous statements about other people in court filings for which they are not involved. And I think this is, in a way, David's opportunity to drag HeyRob through the mud in a legal filing, because we've seen him do it before. It's my opinion that could be actionable, and it's also my opinion that could be something that could be referenced as a complaint to the bar. That's not legal advice. It's just something that I would consider. I would consider if I were involved in such a case of lawyers violating ethical rules, getting involved in things that could be conflicts of interests, especially about a commentator who's referencing a lawyer who's representing someone who's indicted on 14 felonies and criminal action. I see that as conflicts of interest. So I think these are problems that can't just be explained away by David just showing up. And I hope Rob's attorneys see that as well and raise those issues to the court. Oh, let's see. He says threats and harassment are not merely immoral acts. They are crimes in the state of Arizona, and they're subject to lawful restraint. Yeah, I know. I just read that. Some odd context aside, why odd context? Why do we need odd context at all? Stick to the elements of the case. Stop it. The issues raised by this case have already been conclusively resolved. Conclusively, well, according to what trials, what cases? Conclusively resolved by the United States Supreme Court and Arizona appellate courts. As these authorities explain, the right to engage in free speech is never without limits. And MLS made some interesting comments about the right versus a right. Some of it didn't make sense to me the way he explained it, but he explained it as being contradictory statements as far as rights in the Constitution go. I was trying to entangle it more, but I didn't quite have enough time in my legal research this afternoon to really come to a conclusive explanation of that. So rather than overly speculate on stuff that I didn't have enough time to really research, I'll just keep moving on. But that is an interesting point where it comes to rights as they are given in the Constitution versus rights and protections as they're given under state constitutions, which it seems as it pertains to Arizona are a little bit more expansive than just the First Amendment of the U.S. Constitution. So I thought that was an interesting and salient point that MLS, whether you like him or not, made in his commentary looking over this particular case with the injunction. As the right to free speech is never without limits. Never! I might do some dramatic insertions. Just because David always likes to add words that are bolded and underlined that really are unnecessary. That is particularly true in cases involving extreme, egregious, and vicious online attacks from an obsessive, mentally unstable individual, as occurred here. That's rich. That's rich, coming from someone who's representing someone who is, in my view, is unstable as to fake multiple twin pregnancies with multiple men and then accuse multiple men of sexual assault of various forms. How is that not mentally unstable? And then not only did she do that, but she went so far as to fabricate documents and take identities and perjure herself and just go on and on and on and on, according to the state's criminal complaint. It's just wild. So, methinks thou dost protest too much with calling people mentally unstable. And David himself, again on Just J Hips, and I clipped this one. I've got a bunch of David Gingras clips from his appearance on J Hips' channel. Did I say that right? Wait, that just sounded funny in my head. I did do some clipping. I've got some editing to do, and I will have some more things to put in my soundboard. So, well, that's what he gets for making a public appearance on someone else's channel, even though he's banned for life, he said. Accordingly, this is line 26, the motion to quash should be denied. Miss Owens should also be awarded her reasonable attorney fees and costs pursuant to ARS, etc. And I asked the question, if he's pro bono, is this a money grab, as I sort of alluded to earlier? What costs does he have if his client isn't being charged? Other than filing fees, I don't know what. I don't know how that works. Let's see. Little chat check-in. Good heavens, chat, you've been busy. Oh, good for you. Let's see. I always like Bruce's comments because, well, they're easy to find. That's why I made Bruce a mod. DSG always has this idea that if he wins a case, he can just retroactively fill out his timesheet and get paid. That seems to be what he's suggesting here. Let's see. David likes a rug too. I don't know what that means. People who talk about nice, great, moral, they are usually the opposite. That would be my opinion, based on the conduct we have observed him do in the last over year in his representation of Miss Owens. Marcus says, maybe wonder he will win a case and find out that isn't the case. Well, we'll see. Robin says, it seemed like the legal professionals were sticking together, giving special treatment. It certainly does in some regards with certain cases. I don't know. Be specific. Exactly. I bet if you have to say your thing, you're not the thing. Yeah. And Bruce, in case you didn't know, folks, is a moose. Very good. Lots of free time. Bruce is the exception. DSG went from the Conor McGregor of litigation to the king of credit karma. What a downfall. He wants to be a jack of all trades and a master of what? I don't know. Maybe none? His previous performance was a little embarrassing. Well, not a little. It was very embarrassing. And he sort of patted himself on the back with on Jay's channel, how he was working so hard to represent her and He went so far as to say she's a good no, he didn't say good friend. He's a friend and he's concerned about her well-being, which to me goes beyond the pale for attorney-client representation. He sort of backhandedly talked about people saying that maybe he's in some kind of relationship with Laura. Interestingly, I will point out, for those of you who followed Jay and watched earlier today's stream with David's appearance, he did not deny any relationship. He just sort of mocked people saying that they could be in a relationship, but he did not verbally state that I heard that he was denying that they are in fact not in any sort of relationship. And then he goes on to say that she's a friend and he's concerned for her well-being. So I'm seeing what I believe are mixed lines. I think there are some boundary issues there. And again, it's my opinion that he has some boundary issues and he has an unhealthy infatuation with this particular client. Let's see, what else? What else is going on here in chat? Has a sword and a shield. Yeah, well, live by the sword, as they say. Dingus just ran into Queen Jennifer. She doesn't suffer fools, fraudster as well. Like I say, buy stock and popcorn. Now is the time. The 10th bar complaint, he gets a prize. Well, if they were to hand out prizes for bar complaints, he might be a grand prize winner. I don't know if anyone else has received so many honors. There could be people with more. I don't know. I'm not sure the Arizona bar actually keeps tab of how many complaints they total up for each bar carrying member in Arizona. Emily Laura Wilson says both Blora and Dingles. Blora. That's hard to... My TMJ doesn't care for that so much. Blora. Yeah. The jaw diphthong doesn't work so well for me. And Dingles. That could work. Dingles have nothing of value to bring to the table. Folks that feel compelled to constantly declare how awesome they are the most insecure, vacuous troglodytes on earth. That's certainly a fair opinion. Bloviating Jingri yet again. I'm just reading more comments. Maybe my microphone is a grower, not a shower. Well, I don't know, Bruce. If you saw the length of the boom it's on, you might be surprised. No thanks, MK says, in quotes, mentally unstable, end quote. What a prick. That would be a fair representation. We're talking about nicknames of Laura, other things. Golly, Moses, I can't get caught up. He thinks David could get removed from all her cases. Oh, that's interesting. Who was saying that? I think I scrolled too far. Okay, I won't get caught up. Aaron Runkle would die if he had to read this. I hope Runkle does. I hope he does. I like sort of his dry wit when it comes to some of these things. I get some giggles out of him. Let's see. Bruce says, I think the thing for Robin as an attorney is that they need this case to be over before they could do anything like a bar complaint. Yes, I would agree with that, Bruce, and I meant to say that, but I didn't quite get that far in my thought pattern. And again, I'm not making any sort of legal suggestions because, well, I'm not qualified to do so. I may state my opinion on things, but I think there is an avenue they could if they were to choose so, depending on a number of things. I can see an avenue for them making complaints. Whether they will or not, that's up to them. Bloviating. Yes. Well, he is full of hot air. That's my view of David Gingras. Let's see. Everyone's just kind of meeting everybody. It's all kinds of things. What clinical diagnosis is DSG using to determine that Rob is mentally unstable? Very good point, Bruce. David Gingras, as far as I'm aware, is not qualified to make any sort of medical expert opinion whatsoever. And that was one of the areas I think could be worthy of a complaint, in my opinion. Just saying. Another lawyer making such claims could be problematic, in my view. Let's see. Elo claimed in bankruptcy court that due to her lack of income, that filing fees have been waived for her. 0 fees, 0 attorney fees. Yeah, I was thinking that as well. I didn't say it quite that way, but let's see. She got it waived for the appeal for Owens v. Maricini, if I recall correctly. So a Ducky says, so a person that writes blogs about being mentally unstable is saying someone else is mentally unstable. The irony. Robin says at DUI hearing, the judge and his lawyer were whispering together so spectators couldn't hear, giving special treatment for legal professionals. Yeah, sidebars and that kind of thing would be concerning. I think Rob did make mention of that after attending that hearing. I got to keep the liquids going. I'm having to hold the fort down by himself. Apparently, Jeep Daddy's decided he just doesn't want to show up yet. The length of a book, is he going for a baker's dozen of bar complaints? Well, he could be. He could be. He may receive them. He may not. We don't know exactly what's going on with the bar complaint status, the status of the bar. And David's PR move on Jay's stream, he sort of danced around it a little bit. He and Jay apparently had a discussion before going live about what David would and would not talk about. To my shock, Jay didn't mention all those things that they weren't going to talk about. Although, there was some peppered comments being made. Look at me, mommy. I'm a real bankruptcy attorney now. Bruce. Oh, Bruce is so funny. The length of a boom arm, don't threaten me with a good time. Well, Bruce, we'll meet up for lunch. We'll see how much fun it is. Let's see. IH is free in Arizona. Not a special waiver needed for that part. Oh, is it? Oh, so filing for an injunction is free. That's interesting. I did not know that. And Bruce says, and I think I finally caught up, bar guy, hurry up. I concur, Bruce. Hear, hear. Okay, number one, introduction. And this is more irrelevance. So this is a lot of victim persuasion narrative, trying to make Laura look like the victim of just vicious, awful, criminal, terrible things. And this is where I agree with MLS. Again, whether you like him or hate him. I didn't see things that rise to that level of harassment based on my understanding. And again, I will repeat ad nauseum. I don't practice in law, but how I understand things, I didn't see that. Sure, as we've said before, Rob said some things that we may not agree with. He may say them in ways that you don't like, but yet it's his right to say them, per the First Amendment and other protected speech protections, be they constitutional or constitutional, that being federal or state levels. So, I don't agree with everybody that covers this case. I don't agree with everybody that says things in certain ways. Some people say that calling people names is, okay, they wouldn't do it, but it's not illegal to call people names. You cannot, however, accuse people of crimes they did not commit. And David Gingras, in his filings mentioning Lauren Knighty, in fact, did such a thing. And Lauren, to her credit, pointed that out and filed a thing with the court pointing out such, and tried to get that part sealed, if I recall correctly, was what Lauren sent to San Francisco. So, yeah, it's just, again, I think part of this is legal maneuvering for David trying to represent Laura. And I think this is also David taking his pound of flesh out of Rob, who he doesn't like, for overtly talking about everything in this case, and doing so in terms that Laura Owens does not like. And when it comes to David Gingras and his DUI case, things that David does not like. So I think it's the double-edged sword David is trying to swing around here in Rob's direction. The introduction, the facts of this case are disturbing and present a textbook example of why Arizona has strong anti-harassment and anti-stalking laws. He was not accused of stalking her. So already we've got a problem. I'm surprised I didn't highlight that. Laura Owens is a 35-year-old resident of Scottsdale. See, he's naming it. She currently lives at home with her parents where, among other things, she provides care for her elderly father, Ron Owens. Prove it. Is she qualified to be a caregiver for someone of his more advanced conditions? Does she have CPR training that, if I'm not mistaken, is required in the state of Arizona to be a quote-unquote caregiver? Does she have that certification? That may be something Rob himself brought up in one of his conversations. I'm not sure that she does. She may not. If she does not, representing her as a caregiver, or that she provides care, which is essentially calling her a caregiver. I don't know if the laws of Arizona consider those different things. There's a problem here. There's a problem here representing her as such, I think. For 40 years, Mr. Owens, and again, all of this stuff for pages is really not relevant to this case. We're talking about Ron Owens, we're talking about the family and other people. But I'll read it just for completion. Mr. Owens was a nationally recognized talk show host in the San Francisco Bay Area. Laura also rides horses and has published music, including songs about her love of dogs. She's also published songs saying how bad, just want a chance with you, hoo, I got it bad, give me a chance with you. Talking about her obsession with men she can't have. So there's that. We covered that. We covered the songs of Laura Owens. I think she told on herself in those songs, and those songs are, I'm trying to remember, about 13 years old, if I'm not mistaken. I think they were released publicly via a third-party distributor on YouTube. You can find them. They're out there. And you don't have to pay for them because that third-party thing distributed them ostensibly with permission from Laura Owens because they can't release them otherwise. So she tried to get herself out there, and when it didn't make money, I think they became sort of a public domain. That's how I interpreted how that happened. Anyhow, that's a digression about her country music career. And it was so heavily auto-tuned. And, if you want to see my opinion of Laura Owens' country music career, you'll have to go back quite a ways into my videos and take a look at that. They are fair use because I talk about them from an analytical perspective, both in terms of structure and lyric content, and how it was sort of foreshadowing the problems she would present for herself later in life. Defendant HeyRob, we're at the next page here, and see, we got pictures. We got pictures of her in the red sweater picture, and obviously riding on horseback. I'm not sure if that's the recent one. Is that from when she was supposed to be in San Francisco and she was in Scottsdale? Under an ADA requirement, she demanded ADA accommodation, and rather than being at her hearing that for a cause of action she filed, she was jumping horses in the kids' competition. I'm not sure. I'm not sure which picture this is from. Somewhere I've got archive images of the Instagram postings of her skipping court and being at a horse show. I've got that. So again, these are irrelevant images. There's no reason for these to be here at all. Defendant HeyRob is a complete stranger. Okay, so we admit that Rob is completely unknown. Oh, look who just popped in. Look who just popped in. Okay, we're going to take a little break.
Oh,
Are you feeling better now that you've had your mane trimmed?
I mean,
Did you get it colored too?
No, not this time. There's still color left in it.
Fair enough. You know, we could have hair care talk just like Megan Fox.
I mean, we could.
But she's got longer, wavy locks of hair.
Yeah, I can't compete with that.
And it seems like every few months she's got a new hair care regimen. I'm not that picky. I find what's cheap and in a big bottle.
Well, I mean, you've got these long.
Yeah, we got the facial whiskers. That happens.
Yeah, well, that's what you get for hanging out in a cubbyhole for as long as you have. You have to play the part, I suppose. Well, anyway, hello to everyone. I do apologize that I am late. Actually, I'm not late. I arrived just on time. The Jeeper is never late. We arrive exactly when
you're. What's that phrase from Princess Diaries? We are never late. Everyone else is simply early, or something like that.
Sure,
I should
go
get
with that.
a couple of those as clips. And we never rush. We hasten. There's some great one-liners from Julie Andrews. Bless her heart. She may not be with us for much longer. She's no spring chicken. Oh, let's not go there. Too many people are dying lately.
Yeah, let's not.
Too many good people.
Do that.
IB says, what does her songs have to do with the IAH request? Exactly. But David Gingras saw fit to mention that she has songs. It's irrelevant. It's needless waste of court time. Let's see. The two do not know each other and have never interacted in any capacity. So how could he have harassed her if they've never... Questions. We have questions. Questions. I have questions that need answered. That's from a show. Never mind. The only knowledge Miss Owens has regarding HeyRob is what appears in online searches. Okay, so we're acknowledging that Laura is going around looking up about herself.
Oh, well.
I think I'm hearing myself through your earbuds.
You can't because it's not...
I'm hearing some sort of feedback. It's low level, but I'm hearing it.
Not from...
Oh,
not
dear.
coming through on this side.
Okay.
I don't know what settings you keep
mine.
screwing around with on your side, but...
I haven't changed anything since last time, so leave me alone. But it's,
No, I don't
it sounds
leave
like
you.
someone's holding a telephone of me like a second and a half apart, about 15 feet next to you. I just hear it in the background.
Okay, well, that's muted. That's muted. Computer, I don't know, muted.
Got me. Okay, I'll just have to ignore it. The
Don't know.
knowledge. Oh, what?
It's like, I don't
Okay.
know. It's not, yeah.
Okay, all right. Like, maybe it's a StreamYard hiccup. Other people they've had some StreamYard issues lately too, so I don't feel alone in that matter. Okay, what appears in online searches, and of course, the acts of harassment by HeyRob, which give rise to this case.
Are you reading off the page again? Because
sorry, yes.
all we can see
let me
is
put that back up.
our two crazy mugs.
Sorry, I forgot to put it
screen.
back. I forgot to put it back. There we go. Were you listening in the car? Are you at least sort of
I
caught
was
up? Or?
a little
Oh,
bit
God,
after I got my dinner. I sinned greatly for dinner, but it was
So did I.
absolutely worth it.
I sinned earlier today, and I had some. Don't tell my doctor. I had a couple pieces of fudge with almond extract, and oh my goodness, fudge with almond extract, folks. Oh, don't put the almonds in it. Don't make it crunchy fudge. Just put the almonds in it. The almond extract in it. It tasted almost like cherries. I was like, oh, what is this? This is sort of
Interesting.
magic. It was called fantasy fudge. It's very good. I was naughty. I was naughty today, but I didn't have anything to eat in the morning. It was late morning by the time I ate it. So
I'll
it's
probably
like,
cap
well,
off
all right,
my...
you know what?
I'll cap off my naughtiness by having some leftover pie from the weekend activities. Not that I need any more, because like I've definitely done a number.
That
of
reminds
things.
me, I should cut up a pie and send it your way.
Yeah, sure, if you want. Or maybe I
Then,
just need to go and
someone else
accost
can
you.
share in the blood sugar spiking.
I will do plenty good on that on my own today. Thank you very much.
Oh, very good. Next time you venture to the wilds of the cubbyhole, then
Yes.
I just have remembered to pull it out of the freezer. Okay, let's see. Hey, Rob. Hey, Rob operates several social media pages, but we only list 2. The YouTube and an Instagram. How's that several?
2 is several. Okay, that's cute. But
yeah. And like I say, I think this is David trying to just make digs, and I think it's unprofessional. He doesn't like Rob reporting about his stuff. He doesn't like Rob talking about. I don't like him talking about Laura. I don't like him talking about my Laura, my girl Laura that way. He's just said some vicious, vile, icky, disgusting things about my girl Laura. I don't like it. I don't like it at all.
I don't like it at all.
I want to say that. I'm so glad Laura's suing him for an injunction. Because he needs to we need to put a gag order on that. Hey, Rob, we just don't like him saying anything about anybody. Yep. If he can't say something nice, the First Amendment should just put a ball gag in his gog.
Yeah.
What? I don't know what I said. Okay, I better get out of that. I'll get stuck in that voice. I've done
welcome
it before.
Welcome back to reality.
I've been stuck in that one for half of a show.
Oh, dear. Yeah, no.
That one made the rounds, I learned later. That one made the rounds that I came off the rails completely with a pseudo-Texan accent. It was a good moment. I went back and listened to it. I was like, that's not half bad. I might have a character to develop here if I were ever to do stand-up or something. There might be something there. Douche Canoe from Texas. I don't know. I haven't played with it. I'm too busy. Much of the content posted online by HeyRob is nonsensical. For example, his Instagram account, God, I've got to find that magic spot again in my lenses. His Instagram account contains a video dated from August of 24, which appears to show him driving through an Arizona neighborhood, albeit with the camera turned upside down. Why is this relevant? The video and much of HeyRob's other posts contain no likes and no comments from others. This is not relevant.
Yeah, what does any of this matter?
The court should toss this shit out just for being irrelevant. Many of HeyRob's YouTube videos are similar in that they reflect little to no audience attention. So what?
Yeah.
That's not relevant.
Yeah.
Many videos
Especially
have
to
10
the
views
injunction,
or less.
like, who gives a shit?
Yeah. Many videos have 10 views or less. Some as few as a single view. So what?
So what? You're almost making the case for us that, like, what? Nobody watches his channel, therefore, like, why are you being, like, why is the harassment? What the fuck?
How
like,
is it?
Jesus.
Therefore, ergo, how is it harassment? Well, not to disparage HeyRob's popularity or lack thereof, but we're going to disparage HeyRob's popularity or lack thereof.
Right, yeah.
As Jack Fox always says, anything that starts that way, when someone starts by saying, what is it, truthfully, or there's a couple of buzzwords. In all honesty, well, are they going to be honest? That should raise a flag.
Or you weren't being honest before, or fully honest,
right?
In all honesty,
right.
Maybe
Jack Fox
honesty?
would make that case, make that point. It is clear he is not a journalist speaking to a broad audience, comparable to, say, the New York Times. And as I've put in, see, I've got scribbles. So what? And then we have some thumbnails of some of his videos. How is this relevant? You're wasting the court's time.
Yo,
they should throw this. Go ahead.
It's like, what are you trying to say? Like, it just yeah. Oh God, it doesn't make sense. But well, I mean, it's not a lot of things.
It gets worse. It gets worse.
Says,
this filing gets worse.
I can't believe it.
And it happens in the next sentence. In addition, so now we're going to dox him. This is David Dingus's chance to dox him and smear everything he's ever done. So this is why I think there's a conflict here that David cannot ethically represent her in this. That's my opinion. In addition to his limited social media fame, it appears HeyRob previously worked as an actor on low-budget films, such as Love Gods from Planet Zero and Golf Cart Jihad. Is that? I've never heard of this, but I don't watch it. Maybe it's independent. I don't know.
Golf Cart
He's an actor.
Jihad,
Good for him.
huh?
Sounds funny.
I know. I kind of want to watch it. Maybe we can get
Jihad! Yeah, I'm thinking of a Robin Williams joke there.
Some like riding around in a golf cart and suddenly, "Ah, la, 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 la," and then off we go. Yeah, just I don't know.
Did you ever see any of those 80s movies like with what's her name? Is it Sharon Stone? Jewel of the Nile? Michael Douglas, I think.
Oh, maybe.
Yeah. So
I feel like it's just. I feel like this is material right out, like made perfectly for. Well, a title like that could be made for MST3K or a riff tracks, sort of thing. Like put Golf Cart Jihad on. Wow. Okay. Yeah. I mean,
IB says he's just trying to insult Rob on the record. I believe that's true. Just like he tried to do with Lauren Knighty in San Francisco when he accused Lauren of being a crime ring goddess of darkness or whatever the phrase was. I made a lot of jokes about it at the time because it was just ridiculous. He goes off half-cocked, and he's aware of this, and I've got clips of him being aware of it now, that he's just he behaves like an asshole whenever he's writing things. And
keyboard warriors tend to.
Why the Arizona bar suffers him to stay a licensed member is beyond me.
Maybe they like his bar fares and his fees for membership. I don't know.
Wallace says, what the heck, YouTube? Why am I only finding about this live an hour in? I don't know, Wallace. YouTube is asshole.
Wallace, I found out about it an hour into it too. And that's
really? So it's not pushing notifications. Interesting.
No, I'm being dumb. Okay. I knew about it, but
we talked about this yesterday.
Yes, and I needed to go get fish and chips.
He had a date with his hairdresser.
I got this takes a lot of effort.
You've got a little bit more of what's that guy's name? Scott from Pentatonics. You've got a little bit more of that look being freshly shorn this way.
Okay.
Why am I blanking on his last name? The tall guy, the bass. Or no, he's the lead. Sorry. Bass is the other guy.
I don't know. Yeah.
Scott something. I'm just totally blanking. That's all right. Consider Connect says, I was hoping to be here live, but may have to dip out. That's all right. We love our replay crew. Replay crew. Make sure you hit those buttons. I'm done. I'm done already. We're not even halfway yet. I was debating. I was sort of loath after hearing Dingus on Just J Hip's channel to even go over this. I was like, do I really want to do this?
Maybe there's some TLDR and we can just zoom through some of the bullshit and like, hey, there's pictures inserted at line 4. Like, who gives a fuck about that?
Yeah, again, why is his IMDb, which kudos to him for having an IMDb. Why is that relevant? It's not. Zero. Zip, zilch. They cross paths. Oh, see, first we say they never met, and then we say they crossed paths. When Miss Owens filed the pro se paternity action against... What? We're contradicting ourselves all over the place here. Miss Owens alleged she became pregnant after a... See, now we're saying Miss Owens alleged. See, there's interesting distance there all of a sudden for him. That interests me. The allegation with the case writ large, the original writ large eventually gained massive attention on social media for two reasons. First, because Mr. Eckert was a former star of the popular reality dating show The Bachelor. And second, the case drew so much attention because Mr. Eckert accused Miss Owens of fabricating the pregnancy. I'm not sure those are the only reasons. I had no idea who Clayton Eckert was before our Law Talk with Mike covered the case. In the Who's Your Daddy playlist he has, where it was a recording of her at one of the, was it the Judge Judy? I think it was the Judge Judy hearing, or it might have been the Judge Gail Ketsis. So it was one of the early hearings with Clayton before he was represented. So I've seen this, if not been involved for quite a long time. I know too much. That's why I can't go get deep in on the What the Hell's case. Chat was talking at length about other tangential people to What the Hell's, and I'm like, I don't know. I follow enough What the Hales with Megan and Tug, and that's all I can handle. All the other people who've allegedly been stalking some of the principals in that case, lawyers apparently being sued for stalking, and they're now talking about Laura Owens themselves. I'm like, I don't know about this. I don't know about it. I'm not hip to all the lingo.
Yeah, one has to divide and
I don't have that much time.
conquer this stuff, right? Because like you can't.
Oh yeah,
one person can't just like analyze everything. You would be on here every night for 3 hours.
I would be like Tug. I would be on every day. Tug is on essentially every day. I don't know how that man does it, and has 2 kids. Bless him. Oh my God.
Yeah, so like divide and conquer. It's totally fine.
You have to be a master of timekeeping to do this full time, to cover stuff daily, and have a family and have parent. I'm impressed. I was going to say shocked, but shocked and impressed. Tug is just a master of many things, I guess. Oh, let's see. This accused of fabricating pregnancy. Now we're talking about Owens v. Eckerd, which it's not relevant here. It's just not. This is an injunction for harassment. Stick to the harassment. We don't need to blather and bloviate on about Owens v. Eckerd. The court also referred Miss Owens to Maricopa County Attorney's Office, which later indicated to her she was being indicted on several felony counts, 14 to be factual, arising from the case, including perjury and forgery and identity theft or something like that. Taking another's identity, I think, is the actual charge. As of the date of this response, the criminal case remains pending. Miss Owens has not pleaded guilty, and she has not been convicted of any crime. Yet. Important qualification.
Yeah.
The sensational nature of these allegations, as well as Miss Owens' status as the daughter of former... See, now we're going to talk about Ron again. Talk radio legend has caused the case to receive significant online attention. The story has generated headlines in major traditional media outlets, so everyone's talking about it. So what? Although the unusual background story of the paternity case between Owens and Eckerd gives some context as to why we are here, does it? This case has nothing to do with Owens v. Eckerd.
What? No, yeah.
And then he says that case has virtually nothing to do with the harassment injunction sought by Owens. In which case I write, then why do we have all this crap?
Yeah.
Why? Why do we have pages? How many pages have we gone through that he admits in red has virtually nothing to do with it? This should be thrown away just for being written on used toilet paper. In her petition, and that's my opinion that it's used toilet paper. In her petition, Miss Owens explained that at some point, it appears HeyRob became interested in Owens v. Eckerd story. Well, okay, did we meet her in 2023 like we just is working up? I'm getting flummoxed and flustered. They crossed paths at some point in 2023, but they've never met. And then he at some point became interested. Oh, Lord in heaven.
Okay.
As have many others become interested in the story. That much is not surprising and is certainly not unlawful by itself. Well, at least we can admit that having an interest is not unlawful.
Oh.
Neither is talking about it. What is unusual and unlawful about HeyRob is the degree, type, and number of obsessive, bizarre, and frightening posts he has made, which raise serious concerns regarding his mental health. Again, another laughable thing. Another reason this should be tossed. Specifically, as Miss Owens explained in her petition, Mr. Rob has made more than 1,300 posts about her. So what? With many appearing to be entirely nonsensical and or containing disturbing images and or threatening sexual comments. For example, HeyRob's Instagram page currently contains dozens of posts which show Miss Owens crying in distress with her name featured in bright yellow subscript. They're shorts. They're thumbnails for shorts. And we're not talking about underpants.
Yeah, as though memes aren't a thing out there at a minimum, but Jesus.
At least he doesn't try and make this a case that using her likeness, which was publicly disseminated and dispersed, which she posted publicly, would somehow be illegal.
Yeah, she kind of did that to herself by trying to put herself out there and all this stuff.
That's an element that appeared in the Hales case. A bunch of them sue other people someday. It's crazy. Between the two cases, they don't escape me. So I'm aware of many of those parallels, even though I don't follow Hales as closely as I do this one. I've debated talking about Hales, but it's just too much. It's just too involved for me. It really is. This is more than plenty.
Yeah.
And it's, it's good enough as a feast. So the footnotes here are slightly interesting. HeyRob has posted more than 150 additional times since he was enjoined from further acts of harassment. Talking about her is not, by law, as I understand it, harassment. There is no law that says thou shalt not talk about Laura Owens. There is no law that says thou shalt talk about Laura Owens only in polite, agreeable terms. That's insanity.
Yeah, that's not how that works.
Not how that works. Making a post about Miss Owens does not necessarily mean HeyRob personally created the content in the post, which Rob says he reshared a number of things. He mentions that. That's not a crime. Fair use, I mean, that's a different argument entirely, fair use. In other words, posting can include publishing both original videos and images which HeyRob created, as well as reposting content created by third parties. Okay. In her petition, Miss Owens claimed HeyRob created, curated, and continues to maintain a playlist of more than 1,320 videos focused exclusively on her. So what?
It's not a crime either.
So what? You know, what he's trying to do is make some sort of argument that it's obsessive and therefore being obsessed on her is illegal and mentally disturbed. Because what he's clumsily trying to do and does a little, well, he doesn't, I don't think he does a very good job later, is like a mens rea argument of Rob's just mentally disturbed in such a way that he's not in a good mind to do this. Therefore, all of this harassment is just, you know, it's trying to build a case
like,
of mens rea.
Some sort of like
Of
going
criminal
from
intent because he's not in the right frame of mind kind of intent.
Yeah, that the line where
it's
it
a little
becomes
bit
the
limp.
difference, like where it be like the line that gets crossed in some like stalking type situations where it's not just like,
Right.
you know, it gets to that point where it's then dangerous. And
because it's
all
unhealthy
that.
obsession, it's therefore stalking. I've seen those arguments made before. Without extra activity, what I've seen of such litigation, they've usually failed.
Mm-hmm.
You can't just, I mean, you would have to have more elements proven factually, I think.
Yeah, and I mean, just like comment on your YouTube channel or Instagram stuff does not that doesn't even come close to stalking, like, or whatever other fancy word you used.
Stalking for Arizona, I imagine, I haven't looked it up, is probably a very clear definition.
I would hope so, but yeah.
Yeah, I would hope so too.
Anyway.
Oh, my chat's building up again. See, every time I click on something, it just piles up. Let's see, Village Newspapers. What color loofahs does the golf cart jihad have? Popcorn, yellow, striped smile. Okay. Duty had judge. Okay, so I guess that the one I was thinking was indeed Duty. That was embarrassing. That was an embarrassing hearing. For Duty. Digress to impress. Paid by the word count. Maybe he's self-paying himself by the word count, Bruce. I don't know. Does he charge by the word in his filings? Not sure. I've not seen those paperworks. Okay, stay current. Maybe it's a StreamYard problem. In paragraph 7 of his declaration submitted in this matter, HeyRob disputes this, but not directly. Well, it's either dispute or it's not. This man. He claims... Go ahead.
No, my brain just broke on that. Like he doesn't he disputes it, but not directly. Okay.
He claims to have posted fewer than 400 original videos. That could be an accurate statement, meaning he has only himself created fewer than 400 videos about this subject, in which case the balance of which of, what are they claiming, 1,320 are not him. But yet Miss Owens is trying to claim that he's created 1,320 and maintains a playlist of it. So what? Who cares if there's a playlist of 10,000 videos about her? So the hell what?
Yeah.
That's not, as far as I know, that's not a crime. Because if it were, it would be criminal to have 10,000 videos of cats.
Oh.
For the same reasons.
Yeah.
Some
and
people
clearly,
might.
PETA should be all over that shit then.
Yeah. Oh, let's see. Without ever addressing the amount of times he has reposted third-party content about Miss Owens, which appears to be much, much higher. Again, so what? It doesn't matter how many times he's done it. As long as people don't come after him for fair use, it's fair game. He's saying too much about Laura Owens. That should be a crime. Oh, he's talking too much about Dingus. That's a crime. Please.
I mean, these people would
break.
love it. They would love that, though, because that's what they're learning from all the way to the top at the Cheeto-stained mansion over there in the swamp of just, you can't say anything bad about me because then it's going to be a crime, and then I'm going to have the ice come get you. So you got to say nice things all the time. Mm-hmm.
I can't digress to that. I can't because I've seen some things today I'd want to talk about otherwise. And I don't want to get distracted. Of course, harassment merely requires a showing the defendant engaged in 2 or more harassing acts. Well, you have to prove they're harassing. Thus, whether HeyRob has personally created fewer than 400 videos about Ms. Owens, or whether he had created and republished thousands of videos, is simply not... we're saying it's simply not relevant here. Oh, someone spare me from the idiocy.
Oh my God.
I think he's harming his case.
You think? Jesus, ChatGPT could spit out a better brief than this. My God.
Oh,
so could Fruit of the Loom for that.
That was a great footnote.
Anyway.
See, you got footnotes are important, folks. Footnotes are important because sometimes they tell. Sometimes they tell on him. HeyRob has posted filthy, disgusting sexual comments about Miss Owens on YouTube, such as the example shown below. I think they're funny. I don't find them filthy or disgusting. They might be a little raunchy, but filthy, disgusting, not in my opinion. In this still image taken from a live stream video, HeyRob displays himself alongside a variety of horse whisk extensions. What's a horse whisk? That sounds like something for your kitchen.
I don't know. Yeah, I don't know.
Is that a thing? Horse whisk? Let me look this up. Okay, chat. Ignore me. Let's see. Horse whisk is without an H. Okay. Oh, it's a thing.
Oh,
it's a thing. Holy hell!
Okay.
Oh, the things I never knew.
Hey, I learned something by joining the stream tonight. That's great.
Maybe some of the ladies in Rob's chat came up with horse whisks. I don't know. Okay, I'm impressed with creativity. That's pretty damn creative. Okay. In the still image taken from a live video, displays himself along with horse whisk extensions with Miss Owens' profile. Okay, it's got a picture of her and things are attached to the back. All right. Simple. Let's see. Sample product names include, quote, sucky fucky, cup in the ball sack, and you just can't swallow anymore, end quote. I'm so glad I have an adult disclaimer. You've been warned, folks. That was the first thing we hit. Before my ugly face even appeared on camera, we hit that disclaimer. There is adult content. But this is not revenge porn or prawn. I'm not monetized. Who cares? This is not revenge porn. There's no nudity here. Where is the, quote, filthy, disgusting sexual comments? Okay, we talk about BJs and cupping balls. Let's see what else. I can't quite read these. Can I make this bigger without it? It gets a little grainy. Minus 10 points to Hufflepuff for the grainy image. Yeah. See the Trixie and Frisky. What is order number no mo blalo? Is that what it says in white at the bottom? I can't quite read it.
Yeah,
So
it's like,
the font's a little funny.
yeah, it's clearing up a little bit on my end a little, but yeah. Like,
yeah, it's not very good for me.
Mm.
The Trixie and Frisky. The next one says, you just can't swallow anymore. One next to it says the Raggedy Skankish. Oh, it's a weird font. It's a weird font.
Yeah, skankish. That's what I see.
Okay. Next one says the Sucky Fucky. Next one says teasing and trapping a man's wild side. I think that's what it says. Teasing and trapping a man's wild side. Yeah.
Like
Okay. Next row says bloody rainy day horse packing. I don't know quite what that means. The cup in the ball sack. Next one says blowing off a trowel for a fortnight. Second to last is hanging banging for dripping fun. Some of it's cut off. And the last one says straddling thyself. Okay, so that's the content of this particular thing that was apparently on Rob's channel, according to the filing here.
And that's
again, I don't see anything that's actionable there. What? We're claiming that's harassment because her picture's in it. Well, if that's the case, then you can't say anything about anybody, and then we have a constitutional crisis. And you can't use their likeness of. And again, it's my opinion that Laura. Let me ask you that, since you're here. Now. Do you think Laura would qualify as a public person?
Currently, no.
Even though she's appeared on public radio shows, on her dad's show. Her and her mother had a commercially sponsored multi-platform public podcast. They've had multiple LLCs operating in the public sphere. Do you think she's any kind of public figure?
No.
Just curious.
Not by those standards.
Okay.
She's like, well, I mean,
even when thrusting herself into the public sphere by releasing her pregnancy story to The Sun and other tabloids.
I mean, I think she tried.
For me, that's the threshold. Once she put her story out there for the public, first as the anonymous woman, and then I think within a month or less, went so far as to go around everyone again and say, oh, by the way, I am the anonymous woman. That is putting herself out there publicly, in my view.
Oh, okay. I see. Putting yourself out publicly, I think I would say that is different than how I heard you ask me that question around if she a public person.
I may not have asked it very well.
Well, and I'm maybe drawing too many distinctions.
Would she qualify as a limited purpose public figure or a general purpose public figure? I think would be the specific question.
And I don't know. What I would do is I would distinguish it between like what some may consider to be a celebrity versus somebody who is not. She is trying to make herself a celebrity.
She certainly wanted to be a celebrity.
Yes. But
she has tried to
want.
Well, yes, wants and gets are different things, but she has certainly styled herself. Certainly, with her LinkedIn being the babe boss CEO girl who did all these things, I would interpret all the stuff she released about herself and all the things she has done publicly, and putting her stories out there as exposing herself as being a public figure of some flavor, even if just limited purpose public figure. But I would say even more so now because she is a criminal defendant, which now not only makes it, like another guy said, who some people in chat don't care for because of the Hales stuff. But he said on his channel, and he's ostensibly a practicing attorney in Michigan. Mm-hmm. He said the public figure doesn't even matter. She's a criminal defendant in a case of public interest. So all that other stuff is really, it's fluff. Even having to go that far to talk about it.
But just because somebody is a defendant or a party in a trial does not make them suddenly this bigger than life sort of like entity. I it is. And maybe you're right about the limited thing where it's just like a temporary pause on that. But like I see a lot of the stuff that Laura has done and David attempting to do here throughout all of
Schnitzel's
this.
here. Hey, Schnitzel.
Hey,
Good
Schnitzel.
to see you.
But like,
And Lauren's
I
still
think
here?
that she wants so badly to be it, but that doesn't always make
yes,
it the case. But if
Widget
she's the one
says
like putting
she
herself
lists
up,
herself as a public figure.
so I could go and edit my profile and do the same thing, and I'm suddenly a public figure. That doesn't mean
If you want to take that risk, right?
But what does that actually mean? It
Don't.
means
Oh,
sweet
and
fuck
Bruce
all.
reminded me. Don't forget her public music country career. I think she would qualify, and I made this argument on that guy's page. Said I posit with everything she's done publicly to try and thrust herself into the public spotlight that she could be considered such. Now, one could argue that's really for a court to decide, and that's a fair argument. But as far as I'm concerned, she's getting what she wanted, just not the way she wanted it.
Well, yes, she has absolutely gotten everything. She's earned every
Her
bit
own
of this. Just
website
her not.
described herself as a public figure, says Lauren.
I look. I get it. I understand that she's listed.
That. I'm sure she does.
Yeah.
Go ahead. Go ahead.
I just
reading chat.
It is. Oh yeah, it's fine. It's like there's that desire to want to be that, and then like actually being it. And I don't know if I'd maybe just be ignorant of this, but like, are the courts actually the arbiters of who's a public figure / celebrity or not? Like, is that?
Well, I think when it comes to litigation, I think the answer is yes, because whether or not you're a public figure changes some standards of litigation, as I understand it. Because in order to prove, say, defamation, this is sort of weird. This injunction is bizarre because how David starts rambling on, he frames this as almost a defamation case, which it is not. It is injunction against harassment, which is a specific thing. So we've got this conflation of both defamation and injunction for harassment at the same time, and it's a mess already. So that's another problem I have with these filings. Lauren says, Bruce, why would you stop anyone from getting that? Now I'm getting an injunction.
So like,
Okay,
is the
chat's
idea
having
then
way too much fun.
is the idea then that if she is considered a public figure that this is all like, by doing so she has opened herself up to all a bunch of extra free speech stuff that like
Yes.
she can't say that she's being harassed by or
Just-
that some that level of nonsense versus a private person, like let's say me, and somebody was coming after me and I'm not in the public, I'm just some dipshit out on the road, like getting mud on my Jeep. So like, but that doesn't mean I'm a
because
public
you
figure.
appear on my channel, I think technically you would be qualified as a limited purpose, especially as it pertains to discussing this case. Now, again,
Fair.
I don't practice in law, and I could be completely wrong. I can hear David Gingras saying, yeah, you're wrong about everything. Well, this is what I have to say ahead with him.
The fucking douche canoe.
Yeah.
I haven't used that button in quite a while. It hasn't gotten much
David
use.
can go completely
Never mind.
fuck himself.
Oh, he could.
But anyway, interesting. Yeah.
It is interesting because, at what point does someone doing YouTube or content or what have you, what is that threshold? And I think that would take someone who practices in that area to really define it clearly. And it may vary by state too. I don't know, but it does raise some questions for me.
I think it only
we
matters
digressed enough about that.
state by state, depending on where you're, what
It
crime
could.
you're getting charged with, and like that state's rules about public figures versus not, or whatever. I don't know. I don't even know if that exists.
It might. Because we could, I'm trying to think of an example. If we were to use, and I hate to say it, politicians,
Yeah.
because they are public figures, if someone were to file, I'm flummoxed. If a politician were to file a defamation case for some nasty thing somebody else said, there would be a different standard the court would have to find for those statements to be defamatory because they are a public figure. But again, this is not a defamation case, even though in a weird roundabout way, I think David's trying to make it a defamation case while also being an injunction case. Because we just talk about, he references, the icky, nasty, sexual comment, blah, 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 blah. Well, what did he say up here? Yeah. The quote, filthy, disgusting sexual
Filthy,
comments.
disgusting.
Well, that's an opinion. That's an opinion.
Yeah, who's to say what's filthy? What's the
That's an
definition of
opinion.
filthy?
That is
What's the
that is
definition of
not a legal
disgusting?
conclusion that they are filthy, disgusting sexual comments, as far as I'm aware. Let's see. Footnote 2. All First Amendment lawyers. That's dangerous already. Qualified all. All First Amendment lawyers understand that at least when they involve celebrities and general purpose public figures, the First Amendment usually protects jokes, parody, even if rude, disgusting. Well, there we go. This is sort of what we're talking about.
Yeah.
Then there's some case law. First Amendment protected offensive parody involving famous public figures. Miss Owens is neither a celebrity nor is she a general purpose. See, now we're trying to walk that back. So we're trying to make the standard easier. See, this is why I have questions. This matters because when a plaintiff is not a public figure, the protection provided by speech by the First Amendment may be much lower or even non-existent. I don't think
I don't agree with that.
Non-existent. I don't agree with that. I think that's an incorrect conclusion of law. But I say that, again, as not somebody who practices in law. The U.S. Supreme Court and Arizona courts have also held harassment and threatening conduct may not receive First Amendment protection at all. Okay, but again, you have to prove harassment. Icky sexual things that are opinions are not, by law, as far as I'm aware, harassment. They're just icky things you don't like.
Yeah,
They may be dirty names you don't like.
Yeah. If that were the case, then like every tabloid on the planet would have been shut down years ago.
Correct.
So, yeah.
And threatening conduct may not receive any First Amendment protection at all. True threats of violence are outside the bounds of First Amendment protection and punishable crimes. That is not being alleged. There's no threats of violence being alleged. And I've got another note that I squiggled in here because the form that Laura apparently herself filled out for this injunction did not reference that. That was not an accusation. And it was not an order of the court for certain things either. Okay, continuing on. I'm getting bogged down in the technicalities here a little too much. Oh, okay. I've got to ignore chat with Bruce and Lauren going back and forth.
Yeah, let them duke it out.
They're fine. They're fine.
Yeah.
I do the same thing in Lauren's chat too. We have great fun in Lauren's chat. In addition to publishing the above comments, HeyRob has done much more. Sure. As explained in Miss Owens' petition, HeyRob recently, on January 14, published a video in which he encouraged viewers to locate Miss Owens by contacting places he believed she might be and by falsely impersonating her in an effort to verify her location. Well, okay, whatever. See petition, blah, blah, blah. HeyRob has also made threatening, demeaning, and insulting sexual statements about Miss Owens, stating he believes she belongs in prison and that the guards... And this is a false quote here, by the way, folks, because I saw this clip. This is the one that Justice for Clayton Official on Instagram clipped and had concerns about. And that was what got my attention a little bit. That's like, okay, that was not something I would say in that fashion. But what Rob said in that clip... And I will recorrect the record here, that the guards there will we will say harass. He did not say rape in that clip. I saw it for myself. I heard it for myself. He said rap. So this is a false quote, and I have a problem with that being in a filing. Again, it's not speech I would necessarily agree with, but Rob is entitled to say that, as far as I'm aware. I'm done. While also referring to her as a, quote, cunt whore. Petition at 3. Describing incident on 11/11/25. HeyRob has further described Miss Owens to virtually every court hearing she has attended. So what?
Yeah,
he is allowed, as a member of the public, you are allowed to observe the public court proceedings. So what? While expressing a desired to? Oh, spell check. Grammar check. Yikes. To, quote, fucking bitch slap her through the phone. Petition at 5. Based on these and multiple other harassing acts, Ms. Owens sought injunctive relief from this court, which was granted on January 2026, and it might have been overbroad. HeyRob now challenges the order on several grounds. As explained below, HeyRob's arguments are not just without merit, they are at best frivolous and at worst intentionally misleading, if not outright fraudulent. I gotta stop doing that. not unless I glue my spectacles to my face. Accordingly, the court should affirm the harassment injunction in its entirety. Well, I don't think they will. The court should also order Mr. HeyRob to pay Miss Owens reasonable fees and costs in an amount to be determined later. Again, he's doing it pro bono. What fees? If she's found indigent, she claimed not to be charged any fees for filing anything. What fees? What costs? I have questions. I have questions that need answered. Finally, have you seen that show? Have you seen that show? Oh, we're not. This is halfway. I got to speed this up. We're halfway.
We're going to be here all night.
No, I'll move it along a little more. But a good show. Falsettos. Oh. There was a good version of it with Stephanie J. Block and Christian Borle and Andrew Rannells and Brandon Uranowitz. Oh, it's fantastic. I was hoping they would release that on like DVD or streaming, but I haven't seen it yet. It's a good show. Good music. I love it. Small cast. That's like 4 or 5 people in the orchestra. Great little show. Love it. It'll tear your heart out. It's one of those. Sort of around the time of
all the feelings.
Stonewall. Okay. But I digress. Finally, given the extreme circumstance of the case, and in the light of evidence showing HeyRob has continued to violate this court's order after it was served, the court should refer the matter. Yeah, this is trying to turn the tables. Should refer the matter to Maricopa County Attorney's Office for a determination regarding potential criminal charges to be brought against HeyRob. Of the hypocrisy. Such charges may include, and this is him saber rattling. Charges may include, among other things, violations of ARS, etc., use of electronic communication to terrify, intimidate, and threaten or harass. That would have to be proven. I think there's some factual disputes. Criminal harassment, felony aggravated harassment, felony stalking, perjury, among others.
Yeah.
It's funny because his client is being accused of similar crimes. The irony. Yet again. The irony.
You know, as I was listening to this in the car on the way over and continuing to process the input here, it strikes me that every accusation here or an alleged thing is more of a confession about somebody's own behavior versus HeyRob actually doing something. It just smells of every statement here is a confession or every accusation is a confession type.
It kind of seems to be, if we want to use such a trope.
I'm fine with it because, I mean, it makes it digestible.
What is this about a cow? What is this about a cow in chat?
Fuck if I know. I'm just playing in with it.
Oh, okay, you're just going along with it. Something about a cow and a public figure. What? This is why I can't pay attention to chat. I just get distracted.
I'd Bruce just being a wise ass in the chat there, finally convincing me that the cow.
If there were any wiser, a moose.
It took the cow in order to convince me what a public figure is. I have no clue. For the record, I have no clue what this cow thing is either.
I better not. I'll just move right along here. How about that?
Yeah, that works.
Discussion. HeyRob's motion raises 3 primary arguments in his defense. The first is a factual argument, while the other 2 are legal. 1, quote, I didn't do, brackets, some of it, end quote. HeyRob denies making some of the statements attributed to him by Miss Owens. As explained below, this argument is at best intentionally misleading and at worst may constitute perjury, just like his client. I inserted that. In short, Mr. Rob made every statement he is accused of. You'd have to prove that. There may be a couple of things that line up with that, but he just made a qualified. What day is it? God, I don't want to go to work tomorrow. It's a qualified statement. Every statement. He made every statement he is accused of. So if something is found to be not true, then, well, another reason to just toss the whole thing. File 13, right along with the bankruptcies. To the extent he has denied this in a sworn declaration, the evidence appears to show. Appears, another charged word. See, I've done a little bit of Jack Foxism analysis here. To show he committed perjury in making that denial. Can't stand this. 2, quote, I didn't contact her directly, so that's not harassment, end quote. HeyRob's second argument is purely legal, i.e. that Arizona harassment law requires the defendant to have direct contact with his victim before relief may be granted. This argument is clear material misstatement of the law, which this court must firmly reject. As I understand it, this is David disagreeing with what the law says, factually.
I mean,
I don't have that pulled up, so I can't go further than that. But based on some other legal analysis, which may or may not be accurate, I don't know. What David is saying is a misstatement of the law is the opposite of what the law says. Or something. Am I saying that right? No, I'm not sure. I think I've just confused myself.
With respect to the lawyers that are working in that space in law, that's kind of a lawyer's job, is sometimes to go and push at the edges of the way that the laws are written and test those theories. Otherwise, there would never be any adjustments or any ways that no new laws would be made, because it would all have just been done. So I mean, I don't necessarily hold too much fault with the idea that you push the definition of what it means the letter of the law actually means. And that's what makes things evolve and get better.
When it comes to factual legal conclusions, I'm going to be a little bit more shy because, again, I'm not an attorney. J.D. Kelly says a parody account for Devin Nunes. Nunes sued a make-believe cow. That's how I got on Twitter. Okay. I guess there's a cow thing.
Okay.
The things I miss on Twitter, and probably for my benefit. Cow, not vow. The Twitter cow was awesome. Apparently there's a Twitter cow we're missing out on. Could that be Ragic Cow? From Ragical's channel? Cow's the best part. Outstanding in his field. Even if I did it, quote, even if I did it, the First Amendment protects me, end quote. As a final point, like many other defendants before him have unsuccessfully tried to do, HeyRob seeks to hide behind the First Amendment. While he is entirely correct, the First Amendment provides broad protection for speech. There is no question that protection is not unlimited. Based on the extensive legal authority cited below, it is clear HeyRob's words, deeds, and actions fall far outside even the most liberal application of the First Amendment. And I've heard some other legal analysis about this. Clearly, we are not talking about non-protected speech. And there are some legal arguments to be made with non-protected speech. Of course, non-protected speech is not going to be protected under the First Amendment. I mean, that's just kind of, duh. And that wasn't an assertion made, as far as I'm aware, in the original filing. We are claiming harassment. This is an injunction for harassment. This is not a defamation suit. Sometimes I think I could be a better lawyer than him. Maybe that's
you
hubris.
Actually maybe you think and do.
Maybe I've missed my calling.
And, it's never too late.
Well, I'd probably make better a living. HeyRob made every alleged legal argument. See, again, we're being very narrow in what we're saying he did. He did everything.
Everything.
All right, the second anything's found that contradicts that, poop, done. In his motion and supporting declaration, HeyRob accuses Ms. Owens of lying to this court about what he said. On that much, what? He does not mince words? Oh, God. Contrary to Owens' mischaracterizations and outright fabrications of what HeyRob actually said, nothing in those live stream videos meets the criteria of ARS, etc. Because this presents a factual dispute, it is not appropriately raised or addressed in the context of a dispositive motion. However, for the court's benefit, it is important to explain one thing as clearly as possible. Yeah, right. After how many pages of useless, irrelevant
blathering?
It appears HeyRob committed perjury. Oh, see, this is just poking. It's just getting the digs in. HeyRob committed perjury in his declaration insofar as he denied under oath making certain statements. That's a factual conclusion that could be disputed. In which case, it'd probably have to go to trial.
An injunction
But let's not
going
get
to
ahead of
trial.
ourselves.
Jesus
Let's
Christ.
What?
An
Oh,
injunction
God. This
going to trial?
We could, if there's enough factual disputes. It's going to come down to whether or not and someone in another comment section was talking about Arizona anti-slap. I had that in a different window. It's buried under all this crap. ARS something. And was wondering where that would apply. Oh, where is it? ARS 12-751A. Which, dare I say, isn't nearly as flexible as what I get to enjoy. I was a little disappointed that Arizona was a little bit more narrow in their anti-slap, but they have not invoked anti-slap in their response, or HeyRob's response, yet. Because I think the first step is, either way, even if they were to invoke it, it would be a motion to quash, and that's what they've done. So either way, the first step is deciding whether or not the court wants to quash it or if it's going to proceed to hearing. And usually injunctions are a short hearing, like hour and a half maybe. They aren't these long multi-day things typically. So I'm curious. I didn't bring that up for everybody, but I just had that there. Because I was doing some research. I spent most of the day researching some of the legal points on this and just going, what is he trying to do here? Other than just be an arrogant ass. Or, as I titled, a condescending ass. Which is what MLS called him, so that's why I used it. So that is a direct quotation, in fact. MLS on his channel called David a condescending ass after reading some of this. So I'm quoting another content creator. Why not?
I suppose the thing that he's trying to do with this, just on my layman's
It's a smear campaign.
and
this is more of the same.
It's just trying to cast doubt on and inject uncertainty into HeyRob's answer and that motion to quash.
We call that a character assassination.
That's what it seems like he's trying to do here, because all of this stuff is just outlandish as all hell and just wordy and just word vomit everywhere. Like, yeah.
Let's see. Widget says anti-slap in Arizona applies to criminal cases too in Arizona. Yeah, I'm sure it does. It's just that the reading of the statute, as I saw it, was carved out a little bit more regarding public officials. Other states have made that much broader to include anyone using free speech in any capacity. So Arizona wasn't quite that broad as I read it and as I understand it. And again, I don't practice in law, so I could be misunderstanding something. And I'm certainly willing to be corrected on that front. But from what I've seen, it's not, I don't think, and this is why they didn't invoke it in their response to the injunction. It's not their first best go-to, I think. The first thing to do is see if you can just get it kicked because it's just such a mess. She's making all these wild, broad accusations. David claims it's somewhere in here that Laura misstated some things and calls it a clerical error. But no, that's a problem. If you're misstating something and misattributing to where it comes from, that's not just a clerical error that can be so easily dismissed. That could have been intentional misrepresentation, as I understand it. Again, that's an opinion.
There's a few clerical errors that we've seen here in just the last 40 some odd minutes into this particular document. So I guess that needs to get trashed too.
I think it should all be trashed. I mean, okay, like I said before, you don't have to like everything he says, but that's not what the First Amendment. It's not protection against being offended.
Yeah.
If anything, it's the right to allow you to be offended.
Yeah, really.
If anything.
Yeah.
It's not to hold your hand and allow you to clutch your pearls. Otherwise, it's no longer free speech. And declared insofar as he denied under oath making certain statements. That's a serious allegation, so let's be extremely specific. The casualness of his tone here is just wild. Just trust me, bro. Let's be... Okay. Using just one example, in paragraph 22 of his sworn declaration, shown below, HeyRob claims Miss Owens falsely accused him of making several violent and offensive statements. So, HeyRob quotes each of these alleged statements and then denies making any of them, asserting that the statements appear nowhere in the transcript, either at the time claimed by Miss Owens or anywhere else in the transcript. He goes even further, stating the quoted statements do not appear in any other live stream Owens cites, for that matter. Emphasis added. And here we have a picture inserted. And the other attorney who talked about this yesterday said, don't use the clip art pictures inserting images. Just reference an exhibit and keep it clean and tidy. This is too much arts and crafts. No, he didn't say that. I'm saying that. Unfortunately for HeyRob, Miss Owens kept receipts. And those receipts show two things. And I agree with MLS in using the term receipts. It's too casual a language for filing, in my opinion. First, HeyRob did, in fact, make every statement. So there he is again. He's stated multiple times that Rob has, in fact, said everything they accuse him of. That would have to be borne out. That would have to be proven. It is their burden to prove that. This is not an opinion. It is a fact. And we're asserting that all of these every statements are a fact. Yikes. And can be easily verified by simply viewing the video, which will be offered in as evidence at the hearing, which will be available here. And there's a link, which clearly, Laura, and there were a couple things that the clips here did show Rob stating some things. So, okay, some things are said. Do they rise to the level of harassment? I don't believe so. They were statements. You may find them offensive statements. Doesn't make them harassing statements. Doesn't make them harassment. In the video, contrary to a sworn affidavit, HeyRob recorded himself making the following statements at the following timestamps. Yikes. 1625. Hello, the poor indigent. Sorry. God, now I'm doing it. If she goes and says I'm indigent because the court said so, 1631. We've got time missing?
So we jump ahead?
That's what I was just thinking. Now I'd have to review it to confirm there's not something missing there. Quote, I'll fucking bitch slap her through the phone, through the camera, whatever I can get her. End quote.
Yeah, it doesn't take 7 seconds or more to read that first sentence.
I really don't want to click on the link.
Don't. But yeah.
Supposedly that's what it says.
Yeah, supposedly.
It's on someone else's channel. They clicked through the stuff. Okay, good for them. I saw it. Some things were said. But again, I don't think they rise to the level of harassment. 1957, pardon me. Quote, she's a funking funking. Is it your turn? Maybe you should read this section. Maybe you should. Maybe it's your turn.
You just want to hear me swear and say all these naughty things.
Well, it's not good if I stumble on it. You're a little bit better at just kind of letting it roll off the tongue.
But it's terribly amusing for me to sit here and
watch me stumble over each one.
Yeah, exactly.
Make an ass of myself, for crying out loud.
Yeah. Well,
1957. Yes, she's a fucking twat. She's a hole. She's a hole, or she's I don't know. That something's missing there. But again, that's opinion. She's not literally a twat, and she's not literally a hole, so that's opinion. That's my notes. I'm glad I took notes. 2005, quote, hello, Laura Owens, is a cunt, period. And recently, comma, a bloody ass cunt, end quote. 2013, quote, I needed to go hang out at the hospitals and find out if she was admitted anywhere or actually had surgery, not just a hangnail up her ass, end quote. I mean, it's intense stuff, but again, where's the harassment? Thus, contrary to HeyRob's sworn denials, he did, in fact, make precisely the statements Miss Owens cited in her petition. And I say, so what? It's an opinion. You may not like it. You don't have to like it.
Yeah.
An opinion is protected. Based on this, it appears HeyRob knowingly lied under oath when he denied making these statements. Please. But there's some elements missing. I'm not going to point out what those are because I'm not doing Jingy's legal research for him. But he's missed some elements. Again, I should bite my tongue. Don't give him any help. The fact is incredibly ironic. Yeah, is it ironic given what your client is being criminally charged for in 14 felonies? Is it?
Yeah.
Is it? It's incredibly ironic given that Miss Owens has been charged with perjury. Please. And although she has not been convicted of any crime yet, Mr. Rob has posted hundreds of videos calling for her to be convicted and sent to prison. Okay, so what? That's an opinion. He has also laughed about her being raped in the ass while incarcerated. The irony and boundless hypocrisy cannot be overstated. Well,
I don't think
if
irony
hypocrisy
and-
were a crime,
Yeah, hypocrisy and irony are now criminal.
maybe in Jingy's
Okay.
mind, they should be. And if that were true, he would be at the front of the line himself, in my opinion.
So it would.
I mean, really.
Yeah.
The guy who said, if she's lying, I'll drop her. He can't drop her. He's infatuated, in my
No,
view.
he can't. He's
He
quite
can't leave this
clearly
alone.
demonstrating he's incapable of doing so.
Yeah. I mean, I think any reasonable attorney would have walked away from this long ago, as many have. She's been through what? Over a dozen, I think 16, 17 lawyers? I would have to count them. It seems like it's more than a dozen in total. That's not a good sign. I don't think. In any event, HeyRob's first defense denying that he made certain harassing statements. An opinion is not a harassing statement, however colorful or offensive it may be. That doesn't rise to the level of harassment, as I understand the law. Denying he made certain harassing statements identified in Miss Owens' petition is entirely groundless. Exercises of free speech are not harassment. HeyRob misstates the requirements of Arizona law. The second point raised by HeyRob is a legal argument regarding the statutory requirements of ARS, etc., which defines harassment as a series of acts directed at a specific person. ... End quote. According to HeyRob, videos posted on social media cannot meet that definition unless the defendant sends them to his victim. Could be true. Usually harassment involves some kind of direct contact. I think in most, it may vary by state, maybe. Again, I don't practice in law. I'm just assuming. Let's see. First, although HeyRob's videos are about Owens, they are not directed at her. The law's requirement that harassment be directed at the plaintiff means that statements made to others do not qualify, even if the plaintiff becomes aware of them. I remember reading that in their response to her filing. Footnote 3, this is a good one. In fairness, Miss Owens did mistakenly attribute some of the statements quoted in her petition to the wrong source video. Miss Owens' petition claimed HeyRob made the bitch slap statement in a video, blah, 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 in bold there. Petition at 5, this was a simple clerical error. Just like what she said, perjuring herself in Owens v. Eckerd was minor perjury. Please.
Oh, and all those clerical errors in her bankruptcy filings and the clerical errors.
He was
in
going to
other
talk
spots.
about that kind of on J-Hip's stream, but they didn't. He's apparently writing some stuff to clarify all that. I don't know how he's going to wave that away. That'll be entertaining to watch. Because she made very specific written statements, I think in a deposition, as I recall, where she claimed she did in fact have $450 some odd thousand in cash in her personal bank account, when she in fact did not, according to what we heard in the debtor exam on
audio
with the DOJ Jennifer. I'm getting all flustered. I'm just flustered. The quoted statements do not appear in that video. They appear in another video which is linked below. So we're already having to correct the record that she got factually wrong and misattributing statements to the wrong thing. That's not good.
Not a great way to respond to this.
Not a good filing for someone who's already being charged with credibility issues and perjury issues and falsifying and tampering with evidence and so forth. That's not good.
Yeah.
At least I don't think so. Again, that's an opinion.
I kind of tend to agree with your opinion.
This argument materially misstates the law. Putting aside the fact LaFaro involved events which occurred in late 2000, more than a quarter century ago, the case did not involve statements published on social... Wait, what? Oh, yikes. The case did not involve statements published on social media, YouTube and Instagram, did not exist when LaFaro was decided. Okay, why is that relevant? And I just wrote that it doesn't matter where they're put, it's where they are directed. Rather, LaFaro involved verbal public statements made by a political candidate to a small crowd in front of the Tempe Public Library and at a polling center. Given the ethereal and limited nature of words spoken to a small crowd, ethereal? That sounds like ChatGPT words, which are not remotely comparable to videos posted on social media, which remain visible to an unlimited number of people forever. The Court of Appeals held verbal comments of this type did not meet the statutory requirements because they were not directed at plaintiff. Because it was a defamation argument. Yeah. See, I've got notes everywhere. Now I've forgotten what half my notes mean, but I was trying to move quickly in only a few hours. This holding does nothing to help. Hey, Rob. This is so because in the quarter century since LaFaro was decided, the Court of Appeals has established entirely different rules for dealing with people like HeyRob who use social media and the internet to harass, stalk, and terrorize others. Okay, this is
there's
not...
some interesting terms. So now we see what's actually here. Okay. All right.
Well, and again, this wasn't what was filed.
Correct. But this is what he's trying to lay down as the foundation.
We are trying to weave in more things that were not part of the original filing.
And that's not at all a part
I see that as problematic
at all. It is terribly problematic in my less than humble and uneducated and non-law and practicing opinion.
Not non-law practicing opinion. Exactly. This is sort of like what he did with the Maricini stuff. And when he named me and he named Lauren and he named Ducky as, inciting things, and he called Lauren a criminal and all. I mean, it's padding. It's bad practice. It's bad practice, in my opinion.
He's not a good lawyer.
No. Well, I've said that a lot. But he was bragging about how he was rubbing shoulders with Mark Randazza earlier.
Ooh, okay.
I mean, what an arrogant ass. And that's an opinion, too. Although LaFaro remains valid law, the case is strictly limited to the facts presented, i.e. verbal statements made offline to third parties do not meet the directed at requirements of the statute. Okay. This rule has no application here, which is convenient. By what authority? David's authority? What court authority? He can't just say that it doesn't apply without citing court authority.
Well, it's not directed. It's not at. Oh my God! It's like Rob has a video up. It's like this. We have a video up of like talking about this stuff and making occasional snarky comments as we're wont to do, and they're just about the material, and it's screaming into the internet void. Like it's not like either one of them are here on camera. And we're making them at them.
Yeah.
I don't know.
If there were legal authority in this highlighted statement, there should be a citation. There should be a citation of law right there, and there is not. So that's an assertion made. This is a legal assertion made without a proper legal citation, as I understand it. That's problematic. He goes on to say, here's why in State v. Snyder. The defendant was charged with criminal harassment based on social media posts he made about the victim, an ex-girlfriend named BB. After Snyder was convicted, he appealed, raising exactly the same legal argument HeyRob offers here. That's because he only made posts about BB, but did not send them directly to BB. There's some missing pieces here. We'll get to those. His conduct was not directed at her as the statute requires. I've got a foreshadowing note here, but hang on a minute. Snyder argues the state failed to prove. This is the citation, I suppose. Snyder, I lost it. Okay, there we go. Argues the state failed to prove that he contacted or caused communication with the victim between August of those dates. Did not directly send any messages and this is why this case is not relevant, because there was an order of protection in this case with State v. Schneider. There was an order of protection that he could not overstep, and he overstepped that. So this is a misattribution to this case with Rob. These are not compatible cases, as I understand it.
Well,
Rob does not have an order of protection against him from Laura Owens. And we've seen her try to do that. She tried to file orders of protection against multiple people and men, mostly many, to shut them up, to get her name out of their mouths. But for other people, especially ones that she has no relationship with, hang on, that is an infringement on speech issue.
So the question I have is the order of protection. Is it a boilerplate thing?
Often.
where it's I know like it's kind of a no contact order or something like that.
You can't have a third party contact the victim and so on and so forth through a multitude of means. So it's no contact to the victim through yourself, through a third party. I mean, there's some details that vary a little bit based on jurisdiction and municipality and the court, but those are the basic things.
And the court seemed in this case to
go near them. You can't talk to them. You can't have someone else talk to them.
Right. So
talking about them is a little bit different issue.
Well, it seems like the court
even with an OOP
that like the YouTube video commentary in this case, at least this is what Dipshit's trying to argue, is that that Snyder wasn't allowed to talk about BB in the YouTube video while the protection order was in place on social media.
But he fails to note that there was a protection order binding that. He's just saying that, well, this person was charged with criminal harassment because he made a post about an ex-girlfriend and was convicted for it. It's convenient that it's sort of tangential, that there just so happened to be a protection order in place. That's a missing important detail. Rob does not have an existing or pre-existing order of protection from Laura Owens, as far as I'm aware. Problematic case reference.
The foundation is like pretty sandy as far as I'm concerned. But
let's see, and the victim only became aware of the plaintiff's social media posts concerning her when third parties showed them to her. So there we go. It was third party contact with an order of protection. That's not the same thing. I see that as a problem.
Were those agents on behalf of Snyder, or were they just other randos that? Like she may have known, or they know, she, whatever.
It doesn't necessarily matter. If someone's doing third party contact, that can be problematic when you have an order of protection.
Yeah, I get it, but like if
known or unknown, it gets a little funny with. Well, it gets a little funny with third parties because did he instigate them? Did they do something of their own volition? What were the terms of the OOP? What were the restrictions? Because those are important too.
Yes.
It's not just, because again, there are First Amendment issues that come into play with OOPs and gag orders. It gets more nuanced.
Yes,
he's trying to oversimplify is what he's doing.
I get the gag order part, because that's pretty clear. Don't fucking talk about it. But if it's okay, you're not supposed to do this as a third party, that's usually because that person, and again, this is not like non-educated opinion here, but it seems like that's meant for somebody acting as an agent on behalf of the person that has the OOP against them to not go and do the thing. Like, oops, I stumbled across a video about you, like, I don't know. I would love more clarity.
Yeah.
But it's not a grounds.
All the things I've read from David, the clarity seems to be lacking.
And this is not. Yeah. this definitely doesn't
it's his
fall into
problem.
that clarity realm, and it's like he's trying to make an argument out of something that isn't isn't clear, and also isn't the same because there isn't an OOP in this case, like you were saying earlier.
Right. Susan Dippity says, how is what Rob said in his style of humorous commentary more harmful and worse than what David Gingras said about the wives and kids of Omar and Dave Neal? DG had an adversarial pass with Omar and Dave. I can't disagree with that because Gingras said some pretty vile things about Omar and kids and Dave and kids and made some veiled threats of physical harm, as I understood them. I saw that as more actionable than what I've seen of Rob's, which, again, I have not seen everything Rob has done. I've seen some things here and there. He said some things I don't agree with, but it's his right to say some things I don't agree with. Oh, let's see. Mary Smith says, Rob can't go to her home or work or school. Easy enough. Yeah, and actually I had the original order at the bottom from the court. All it said, he can't contact her. Easy enough. He has not contacted her, as far as we're aware. So this is just getting excessive. Continuing on, the Court of Appeals flatly rejected this argument and affirmed a criminal conviction. He's also trying to threaten Rob with being, imprisoned because Rob said nasty things about Laura and being in prison, and said things about David Gingras about being probably in prison. I don't know if he said David Gingras deserves prison or not. Because Rob has talked about getting Mothers Against Drunk Driving involved in David's case and things to that effect. So David has an axe to grind himself, as I understand it, which this matter allows him to get involved. And that's why I said from the beginning, I think this is a conflict of interest for David being involved in representing Laura Owens, just as it is with David representing Laura in the San Francisco matter. I think for similar reasons. Okay. In doing so, the court explained that when a defendant posts statements about a person on social media and the victim learns about the post through another means, that means statutory requirement for acts directed at the plaintiff. No, I don't think so. Because if you talk about anyone on social media, then all of a sudden that's harassment. That's not going to pass constitutional scrutiny. I don't think so.
I mean, it does. Social media does enter into an and blogs and forum posts and stuff that's posted onto a third-party site like that. It does introduce an interesting question about direction or who might see it or not or anything like that. And the law is not caught up to how quickly the media or the internet landscape of this stuff changes.
Robin asks the question, will Rob be able to attend LO's next hearing? That's a fair question. As I understand it, because crud, where did I put that thing? I don't see how the court could restrict him from doing so. I had the original file. I had the original the injunction file from Laura up at one point. I have closed it, which was not smart. Oh, bother. I don't know where to find that really fast because I had it up and I've gotten rid of it because I didn't need it. Restricting him on being in a public place with a public court hearing, I think, would be problematic. That would be prior restraint, and I think there could be issues with that. So they did not, they said don't show up to her work, don't show up to her house, don't contact her. Those are reasonable requests from an injunction thing until the hearing takes place this coming Friday. But I don't recall seeing anything where he can't attend a public court hearing about a public court case, be that about Laura Owens or David Gingras. So I don't think there is a restriction involved there. He may choose to be more careful in those attendances just to avoid any image of impropriety. But that's between him and his lawyer and his legal representation. And if his lawyer says you should have no problem continuing to attend court hearings, he probably will. I don't know that. But that could be conversations they may have had. I believe he has continued to pick up documents from the court. The court can't restrict that as far as I'm aware because she's not there. She doesn't work there. That would be problematic too. I mean, she probably wishes she did work there, but never mind.
Now, if there's no order of protection
Ducky
that's
says we
restricting...
won't know until after his hearing and a ruling, and that's a fair point too. But as the order from the court currently stands with the injunction, I don't see that restriction. But again, I could be misunderstanding something in the court orders as it currently stands. So we'll see. I mean, it's a week. It's not a big loss. It just doesn't.
Well, and if there's no order of protection that restricts like a distance sort of thing out in public, right? Like, because that's pretty typical, right? Don't come within 500 feet of the person or whatever. Then,
yeah. Ducky says, if I was Rob, I wouldn't go to it. She could have him kicked out because of this pending case. I'm not sure about that, Ducky, because I think there would have to be a restraining order first. And as you recall, with the paternity case, she had an active restraining order against Mike Maricini. And now the difference here is that Mike was legally subpoenaed, even though David and Laura both said it wasn't a valid subpoena. That's false. And again, this is why I don't believe things you can... this is why I believe you can't take things at face value in David Gingras' filing. That's what I was trying to say. I think there would have to be a restraining order where that would enter into that territory. But again, I don't practice in law. This is not legal advice. I think he still could, legally speaking, but I'm not 100% sure about that. I'll let the legal scholars who are practiced and have legal degrees chime in on that one officially. That gets into technicalities. It's just, I'm going based on my understanding, but that may be flawed. See, statutory requirements directed at plaintiff. Yeah, okay. Again, this thing about
more
BB was a third
bullshit. Yeah.
Yeah, third party contact with someone that had an active restraining order, apparently. So we'll skip ahead a little bit. Again, the court must stop and consider something astonishing. Why the words? The defendant in Snyder was convicted of felony aggravated harassment, a conviction later affirmed on appeal, because after he was ordered to stop harassing the victim, he posted a video on social media showing an order of protection with the victim's name on and address on it. And again, there's the key word. There was an order of protection. Rob does not have an order of protection, as far as I'm aware. Clear distinctions here. Very clear distinctions that these things should not apply. They should not be conflated. And I can't stand this phrase. Want to guess what happened to this court after HeyRob stopped harassing? We don't need rhetorical questions in a legal filing.
What the
Stop
fuck?
it.
But God.
He committed the exact same felony as the defendant in Snyder. No, he didn't. No, not by a long shot. This used toilet paper needs to be flushed. And look, here's as Lauren posted in her Twitter today. Lauren's made a couple Twitter posts. There, David sought to bring Lauren back into this with Rob and Schnitzel appearing because he's
the fucking douche canoe.
Yeah. Snyder's not the only Arizona case to reach that conclusion. For instance, Raber v. Wagner, blah, 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 involved a defendant who was accused of harassment by sending texts and emails to the victim's friends, relatives, work colleagues, and other contacts. The speech in question was extremely tame compared to the disgusting vile remarks made by HeyRob. Prove it.
Editorial.
Yes. Again, opinion and editorial, and where's the factual basis there?
Yeah.
There's no citation. There's no quote from there. Prove it. Nevertheless, the Superior Court found the defendant's conduct sufficient to support an order of protection. Again, this is not an order of protection. This is an injunction against harassment. Where's the harassment? We have yet to prove harassment here, in my opinion. I feel like I'm saying that more than usual for some reason. The Court of Appeals affirmed. In doing so, the court clarified that notwithstanding LaFaro, the electronic means used to harass, direct victim contact is not required. Again, different cases, different elements, different factual basis. In so holding, we take no issue with our previous decisions that have vacated protected parties rather than blah, 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 blah. I'm skipping a little bit. Again, these points demonstrate HeyRob's arguments that are not only groundless, they're frivolous. How are they frivolous? That doesn't prove they're frivolous. You are quoting cases, or citing cases in some cases, that are not a direct correlation to this case. We're trying to cherry pick certain elements and say, well, that applies. And they were convicted and they were prosecuted and they were sentenced to prison. That's grasping at straws, I think.
Just a little.
Just a little. Part C. The First Amendment in the Arizona Constitution did not protect criminal harassment and similar crimes. The final point raised by HeyRob is a second legal argument, that his conduct is protected by the First Amendment. And I don't remember why I put the factual basis of where she got them. Well, because she got them. She had to go search herself online and dig them up and go get them.
So
Notably,
she
HeyRob
actively went and had to go find it.
She went. She went to go. She sought it out.
Yeah.
If I were to seek out things from my detractors, I'd find them too.
Oh yeah.
And I have. And I've cataloged them just for reference in case certain elements of what they have said, which I do believe fall into some problematic things for my detractors, could be actionable on a legal basis.
Right. But if you weren't doing that
But I'm not just willy-nilly filing injunctions as a result.
Well, you're not, but you're also not in a spot in which, like, if you didn't want to, like, if you decided that you didn't want to hear from your detractors or hear anything they had to say, and
I wouldn't go looking.
Well, it wouldn't go looking, but you're not going to exactly see them all over the place, like wherever you are for those reasons. So it's like you can continue along your life and do jobs, and you can do things, and and you would never hear or know about that sort of thing until the moment that you went out and actually started actively looking at it again. And that's the thing, is like
trying to dig it up.
If you start digging, you're going to probably find some shit about you. Like, I'm sure I could start searching my name and doing stuff and finding shit that people say about me. Or I could just go about my fucking life.
Yeah. Kimbo very accurately says, and I wish I had the time to do this today. I don't. Always fact check Gingras' citations. Most don't apply or aren't published cases. And there is that. There is a whole case he uses, but it's not a published case. So there's not even a citation other than a Westlaw reference. Unpublished cases are not case law, as I understand it. That's problematic when you're trying to use that to prove a case. Because if it's not established case law, it has no authority. If I'm interpreting things correctly from the technical perspective, as a layperson who does not practice law. Oh, let's see. Notably, HeyRob does not cite a single case from the Supreme Court or anywhere else which held criminal harassment is protected by the First Amendment. No one is saying that. No one is claiming that criminal harassment is protected by the First Amendment. Jeez Louise. That failure is hardly surprising given the Supreme Court repeatedly agreed, provided the appropriate mental state recklessness. Oh, and this is where I talk about mens rea. Provided mental state is shown, harassing threats can be punished civilly and criminally in a manner consistent with the First Amendment. Well, I don't think it's the First Amendment that punishes. I think there's other statute, and I think those are the part in USC that punishes, not the First Amendment. I don't remember seeing anything in the First Amendment that says, and the punishment for not following this is as follows. I don't think that exists. Maybe it does in the mind of
The fucking douche canoe.
Maybe it does.
Maybe things exist in that mind in there that doesn't exist. A lot of things qualify in that context.
See Colorado, etc., establishing recklessness requirement in criminal case. Okay, you'd have to prove reckless. I mean, you're missing the elements you claim to have. Where defendant sent threatening Facebook messages to the victim, such as "fuck off permanently." I mean, God, if I could prosecute people for that, I would have a heyday.
I would be in prison.
I'd be rich.
For the number of times that I have told Echoes to fuck off.
Yeah, like just now. Staying in cyber.
I was just using an example. It wasn't another one. I'm not incriminating myself, but you've also told me to fuck off.
No, I would highly recommend you not. Quote, "fuck off permanently," end quote. Quote, "staying in cyber life is going to kill you," end quote. Quote, "you're not being a good human for relations, period. Die," end quote. Yeah, some of those aren't so great. The first one I think could be debatable. That's why I highlighted it. Next page. Consistent with the U.S. Supreme Court precedent allowing for criminal and civil punishment of harassing speech and conduct, Arizona courts have repeatedly explained harassment is not protected speech. And it never was. This is commentary on a public issue of concern. Fast forward. To understand this conclusion, the court need only consider State v. Williams. This is the one that's not published case law. State v. Williams. It's only a Westlaw citation. So really it's this is irrelevant in totality, but we'll read it because he printed it. Williams involved a photographer who harassed a model, primarily posting comments about her on social media. After the victim maintained harassment injunction, the defendant continued making comments about her online, referring to her as a fraud and a real porno actress. Okay, whatever. The defendant also posted a statement about the victim on his Facebook page, accusing her and the judge, this might have been the problem, and the judge who granted the injunction of ethical violations and stating, I can't wait to see you in orange and your judge will be your cellmate. I guarantee, end quote. Well, when you start referencing a judge, that could be problematic for you.
Just a touch.
HeyRob has not referenced a judge. Or Laura Owens tangentially. And he makes the following erroneous conclusion. These statements are virtually identical to the types of comments HeyRob has made about Miss Owens, with the main difference being the volume of content, which is far worse here. No, it's not far worse. The defendant in Williams has posted only a tiny fraction of the amount of content Mr. Rob has created targeting Miss Owens. Despite this, Mr. Williams was convicted of harassment and sentenced to 1.5 years in prison. I cited this as a scare tactic similar to Dave Neal. Just like he threatened Dave Neal with making him homeless, collecting like $100 million from him, and grazing Laura's horses on Dave's property. It's the same sort of nonsense. This sort of stuff deserves
intimidation.
A bar complaint. Okay, I'm just going to move this along. We're getting towards the bottom here because it is getting late, and I'm getting tired. On appeal, the Court of Appeals rejected every argument raised and affirmed the prior prison sentence. In doing so, the court rejected exactly the same statutory and First Amendment arguments. And as I noted here, they are factually different cases. HeyRob presents here, Williams asserts he had a constitutional protected right to use social media as long as he did not contact or engage in unprotected speech. That's, again, referencing an unpublished case. The court's response, no, this is not the court's response. No, he did not. That's not how the court responded. And again, it's not a published case, so it shouldn't even really be included here, in my opinion. The reason, there is no reason for this court to reach a different conclusion. Yes, there is. It's not the same thing. HeyRob's words and actions are clear criminal violations of Arizona law. No, they're not. If anything, HeyRob's conduct is far worse than any examples cited above. No, they're not. This court properly determined as much when it ordered HeyRob to stop harassing Miss Owens. Despite that order, HeyRob did exactly what so many other stalkers, harassers have done, simply ignored the court's order and continued harassing Miss Owens exactly as he did before. And I did actually take something from the original filing. The order from the court, aside from don't show up to her work or her house, was defendant shall not encourage anyone to impersonate or make contact. That is a quote from the filing. That was what got filed in response from the court as at the bottom of the document.
Okay.
It does not say he cannot talk about her. It does not say he can't go to public court hearings with or without her. What the court orders is very specific. We're grasping way too far. This is
no
this is
impersonation,
constitutional overreach attempt.
no impersonation, and no contact. Like, don't encourage other people to contact her.
Yeah.
Is that?
That's why I put this in quotes. Defendant shall not encourage anyone to impersonate or make contact.
Doesn't
So
say
the
content,
accusations-
David. You can't read that as content. That's contact, you dumbass.
Content? What?
It says contact in the order, not content. So he can still make content.
Yeah. Yeah. As far, well, with how I interpret
Fucking
it,
idiot.
sure.
Jesus, Mary and
So
Joseph.
his conclusions are fallacious, I think is the word I want to use there. See, this is why I put notes in. I'm going to pat myself on the back just a little bit. I did a little legal research there.
Good job.
And took what the court ordered.
Start for you.
Like the defendant in Williams, HeyRob is not engaged in protected speech. Yeah, he is. For the most part. He continues committed and continues to commit serious criminal violations of Arizona law, including, it appears, another qualified statement, perjury. At the course of the pleading, God, more grammatic problems. I think he means in the course of the pleading he filed in this matter. He must be held accountable for that abuse, exactly as the Arizona Constitution requires. Every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. I meant to go back and check this in the Arizona Constitution. I did not have time to see if this is an accurate citation or not, or if we've modified it slightly. I don't know. Again, I didn't check it, so take it with a grain of salt. Conclusion, HeyRob's motion should be denied and the court should award Miss Owens her reasonable attorney fees and costs. Again, I think it's a money grab for him. That's my opinion. Because she's bono, according to everybody else, and I think even him on Just J Hip stream. What fees and costs? She's indigent, she's getting, filing fees waived. What fees and costs if he's pro bono? It is a question I have. The court shall further refer this matter to refer to Rachel Mitchell's office for further investigation and charging, if appropriate. Dated February 13th.
Oh, don't worry.
Signed by David S. Gingras,
Esquire. What a shit show.
Jesus
What an
Christ.
absolute shit show. A shit show with a bunch of clowns. That's my opinion.
God. Seems like it's a whole tent full of them.
Yeah, and it only takes two to fill that tent.
They've amply filled the tent.
Egos as big as the tent. And entitlements that are even larger that don't even fit in the tent. The law doesn't apply to me unless I'm attacking other people.
Right.
In which case the law only applies to them. This
Yep.
is the classic case of, it's their world and we're just borrowing space from them.
Well,
It's bizarre. It's bizarre entitlement that's perverse.
in their head, yes, that does seem to be how it is. But
Oh, Marilyn Leo S says, go spend your time outdoors in beautiful weather in Arizona or Cali. Soak it in. She's probably doing that. She did file for travel to ostensibly go visit family who's having issues.
mm-hmm.
If Sister Sarah's sick, that's news to me.
I honestly think this is just one more attempt to try and kick everything down the road even further and delay.
That's so much of it is.
A lot of this.
Let's
is
have a
just
sideshow over here, but the other dates aren't moving because of the injunction. That's not going to happen.
I hope not.
GB Cheese says she needs to spend some time with her financial statements before her date with Queen Jennifer. Yeah, that's coming up. Self-inflicted victimhood.
Yep.
I think, let's see, Widget says, I think it has to go high enough court to become case-like. Yeah. I think it has to be an appellate case to have, what's the word, legal basis? Legal authority? Let's see. That's you.
Oh, this is
Someone's
me.
desperate saying something mean.
Yeah.
But anyway, it's just shy of a guarantee you'll find something. Sure enough.
Yeah, it's all self-inflicted. Like, and I was kind of responding to Ikembo's comment, I believe it was, about like the self-inflicted victimhood thing. Yes, and if anybody has a complex like hers, that's like, oh, somebody's saying something mean, even if it's not like in your direct news feed or something.
Oh, they called me names.
It's not that hard to go like find it. It's not that hard to go find something and log into other accounts or look at things, right? But like, it's also not that hard just to put the fucking internet down for a minute and just like take stock of your life as maybe some mistakes that you've made that have gotten you to this point. But they can't. And I think like this is just speculation. I'm not a mental health professional, nor my lawyer, but it would seem that there is there's this narcissistic attraction, and that's why David can't quit Laura and Laura can't quit David is because they're too fucking narcissistic.
It's a codependent relationship in
and
the
this
weirdest of
codependent
ways.
something. It's like I don't know why, but there's this weird thing between them that they can't quit each other. Like it can't help it. They cannot help themselves.
Yeah. Danny says she wanted to be a reality TV too. That's true. Def comes with the territory, even if wrong. It has been said, and I can't remember by whom now. It was said that because Laura and Sister Sarah were big Bachelor fans, as I think Mom even said this in an interview. I think I talked about it. Seems to me I made a video about them being Bachelor fans, and apparently Laura auditioned to be on The Bachelor or Bachelorette. And I always thought, God, anybody who actually found those tapes or got those tapes from the producers of Laura auditioning for one of these shows prior to her nonsense with Clayton Echard, that would be gold.
Oh, God, yes.
That would be gold. Because Laura has asserted, and I think she may have even asserted in court filings, that she doesn't know anything about The Bachelor, which doesn't seem to be true because there's contradictory evidence to that from earlier years. No, it was an interview with Dad, Ron Owens, about all the women in the house being Bachelor fans. I covered that a little bit. So if anyone out there actually found Laura Owens' audition tape to be on one of those shows,
oof,
that could be very interesting news.
Be very interesting.
And if such a thing does exist, kudos to whoever owns it. Kudos to who owns it, because that could be great newsworthy stuff, and all this stuff involving a former Bachelor. Let's see. IB's gone to bed. Thanks for coming, IB. You're probably already in bed. That's great. It's my turn too, because it's Monday and I don't get a holiday tomorrow, unlike other people.
Oh, that's too bad.
His stupid underlining is really bad. His highlighting the highlighting was me. That was my fault. But the bold, underline, emphasis added stuff is mostly unnecessary.
Yeah.
Especially when he gets into rhetorical statements and questions that, as I understand it, have no basis in filings and pleadings.
That rhetorical question, why
stupid
would you think that would be a good idea?
It's not cute. It's not, it's a weird, I don't know if it's his attempt to be folksy and try and, win a judge over with his style. I don't know what it is. It's weird to me.
It's very odd.
Because there's no factual reason for it to be there, especially when they're erroneous things. Mm-hmm. Susan Dippity says, DG's filings are more full of opinions, conjecture, and paranoia than there are facts, laws, and applicable undoctored evidence. Just like the court with Owens v. Echard stated, and the appeals courts upheld. David's assertions were neither based on fact or law. Keep that in mind. And I always kind of like to hang that in the back of, is anything he's saying and anything he files with any other cases that happen to reference her, or himself for that matter, are they at all based on fact or law? And I would say there's a lot of questionable stuff in what we just read.
And there's
a lot of
it could be a thing. It could be a thing where if there's a lot of questions called into the rest of his cases and stuff, like, woe be unto him if he ends up having all of his case stuff ever pulled and re-scrutinized for that sort of thing. Like
that is an interesting question.
That would be. I
think that would have to be a lot of lawsuits in his direction for that to happen.
Probably, but I mean,
not impossible, but I don't know.
Well, he seems to be making quite the stink over all of this stuff in Maricopa County, and I mean, if I were in charge of Maricopa County's attorney's office there, I would be happy to hire a special person on staff just to go and research all that shit.
Yeah. Keep talking. I'm looking something up really fast for Ike Kimball.
Okay.
Because I took that stupid document down. I think that is correct. Yeah. They also restricted his Second Amendment. I think I saw that.
Right, and that's for
part of the court
injunctions
order.
And
I might not have added.
I
probably should have added it.
It's not terribly unprecedented that, like, for like even when you're going through probable cause hearings, depending on your jurisdiction and stuff, like if you're they're not in restricting alcohol consumption, restricting the possession of ammunition, firearms, operating vehicles. I mean, a lot of those can have temporary restrictions put on them depending on what they're able to do and not, in order for your bond to be valid. So, yeah.
Mary Smith says, someone that is pro bono can be awarded their normal fees if they prevail and the judge says so. Won't happen here. Hopefully not. Yeah, I'll take your word for that. I don't know factually for sure.
Yeah.
This is where I wish, someone like Omar would pop in and say, hey, let me tell you about this. You can. Which guy's okay. I find it weird.
I mean, I have other questions for Omar, but they wouldn't be appropriate for this venue.
Yeah, well, you've asked those questions before.
And I'll ask him again.
Kimbo says, still a very serious stripping of constitutional rights regardless of. Yeah, and that's why I think there are limitations on how long they can kick out a hearing because there is a constitutional restraint that becomes a problem.
For due process, I think.
Greetings to Nick Starro. Yes. I didn't know Nick was in chat. I'm a bit behind, but fees and costs can be travel, office materials, pro bono is just himself won't charge for his time. Nick, I think is he Danish? He's over in the lands afar.
Oh.
Or I want to say Norway, but I think he's Denmark. I may be wrong. Nick can correct me. He's on a different time zone himself. Mary Smith, let's see. I agree. I'm anti-gun, but believe in people's rights. Infringing on someone's rights is just wrong. Yeah. So I mean, I've become more comfortable with the Second Amendment lately.
Mm-hmm. And here's the so part of the deal is that if you are convicted of certain crimes, you are no longer allowed to carry.
Nick is in Sweden. Thank you, thank you for that. I was grasping at one of those chunks up there in the Nordic lands and grabbed the wrong one. Sweden. Thank you. See, this is why chat's so helpful.
Yes.
Nick's kind of funny too. He did some drunken streams talking about this case that were entertaining.
Excellent.
And Rob has appeared on Nick's channel as well. Rob's made the rounds. Good for him, and certainly I'll wish him well in his impending hearing at the end of the week. And we'll hope good thoughts there, and that as they say, justice will be done appropriately. One of those Vikings.
Yeah.
Is it the long hair? He doesn't have one of those Viking hats with the horns.
I was about to say it's probably maybe the horn. Yeah. So, but I do want to make it clear because I've got family members who are tied up in felony cases in certain states, that they have lost their right because of their felony conviction to own a weapon.
That happens
they can't even touch
fairly
it
regularly with felony cases of certain types.
Correct. So yes, I don't yet there is a certain that there are consequences that will remove your right as far as gun ownership, even though there's arguments to be made that the Second Amendment doesn't say anything about ownership, but whatever. But there's other things felons can lose their right to vote. There's other restrictions.
You could lose a number of things being a felon.
There are certain things, if you step sideways of the law, you will lose your rights. You can file to have them reinstated, have your civil rights reinstated, but you have to actively do that, and you have to satisfy all of the things within your probation or
process.
What do they call that? Reimbursement or whatever it is. If you defraud people for $5 million, restitution. So you have to satisfy all those things, and then the court can still say, fuck off. So that's a thing. It's not comfortable to hear about your rights being revoked like that, but it is very real that happens.
Kim makes the point again, which it's a fair point. That some twat makes a baseless accusation and bam, your rights are gone. Yeah, I mean this is one of the struggles with the judicial system, and thankfully most. Can I say that? I'm trying to frame this properly. This is why a lot of these sorts of hearings have a defined amount of time that it has to be heard because it is infringing upon rights and it is infringing upon constitutional rights. I would imagine they have been accurately attributed in Rob's case, which is why they've got a hearing Friday. And whether or not anything goes further will be decided on Friday. So again, we'll think good thoughts for Rob that this will get quashed.
Absolutely.
And I think they filed for fees and costs too. Yep. So hopefully they are victorious, and Laura Owens will owe yet somebody else for yet another frivolous filing. That's my hope.
Add Rob into the list.
Add to the pile.
Add him into the list of the bankruptcy I can't pay this.
Rob gets to be at the top of the pile. It's no longer Clayton Eckert. It's not Craig Gillespie or Mike Murchie. Now Rob's on the top of the heap. Just another straw on that camel's back.
Yep, and it will come crumbling down in a glorious disaster. We're all going to sit here and be like, popcorn time, and let me get out my tiny little violin. Oh no, my poor. Yeah, whatever.
So we'll see. I think like Omar said I think it was Lauren's when Rob was on Lauren's. Is that right? Oh golly, see, it's hard to keep all this straight after a certain point. That
I try not to keep things.
Rob's going to be okay.
So.
I mean, sure, it's been a learning experience for him. That's fine. People learn, people grow. That's okay. Yeah. People do things differently. That's okay. We're not here to criticize that. We just want to see the right thing be done, and I think ultimately it will be, unless David Gingras makes a mess of it like he tried to do in San Francisco, and I think he continues to do everywhere else.
Yes.
Because that's been his performance. System. That has been his track record so far, is to just get involved with Laura Owens and make a mess everywhere. Mm-hmm. And make it worse for her.
Yeah, it's certainly not helping her at all.
Someone else said we should thank David Gingras for moving this case forward and exposing her to all the criminal liabilities that were coming to her.
I mean,
there is that.
Maybe we owe him
David
dinner. I don't know.
For making his client more vulnerable to criminal litigation, I guess.
I mean, maybe we're the ones that owe David a dinner at some point.
I'm not buying that man dinner. I want nowhere near that man or his client or anyone affiliated. I want to be far, far away, unless it's in a courtroom, watching them get raked over the coals for all of their bullshit.
Maybe I'll
That's
deposit
the only
50 cents into his
proximity
prison
I
account.
ever want, is to be in a court of law watching a trial happen where they have to stand in front of a judge and a jury and explain this bullshit.
Yeah.
Well, it's not going to be David in the criminal matter. Not unless more happens and the public defender, taps out and, now I'm defending Laura in a criminal matter, even though I don't practice criminal law and I'm not a criminal defense attorney. And he's just going to take on more and more things he's not practicing in, so it seems. Because I don't know that I don't think he's practiced in bankruptcy court, but here he is sticking his toes in the water, trying to get limited appearance for that too. I mean, it's just, he wants to do everything. How odd.
Mm-hmm. Just for Laura.
A jack of all trades and a master of none. Other than maybe he's a master of flooring, tile, and plants. I don't know.
Mastery of dipshittery, from as far as I'm concerned, but
making an ass of himself. But that's his own folly. He's choosing to keep going with this rather than just walk away.
Mm-hmm.
Because Laura's a friend and he's concerned for her well-being, I think was the quote.
Right.
Okay. I don't believe that. I'm not buying it. I think there's more to it than that. And I talked about that at the beginning. I don't want to repeat myself because it's time to go. Have you had enough? I've had enough.
Yes, I've had plenty. Well, not of my drinks. I've got a couple more rounds to go. Because I don't have to work tomorrow.
Jerk.
You're welcome.
Yeah, I know. While I'm slaving away.
Slaving away. Oh my God.
Well, it's good for me. It gets me off my my chubby backside and, burning some more calories and carbohydrates. So there's a silver lining there.
Yes, indeed. Well, thanks so much, chat, for joining and commenting and all the engagements. Please don't forget to mash all the buttons and let's get Echoes over that 1,000 subscriber mark.
ever so inching closer. It's like watching a slow moving train sneaking up to the coupling of a car. It's just, it's gonna click at some point.
Almost there.
I can hear the screeching of the wheels on the tracks. It's that kind of agonizing thing. Okay, everybody, thanks so much. Until next time, say bye.